Manish Gupta sir, a distinguished practicing company secretary, a former president of Institute of Company Secretariat of India, presently a director at ICSI, Institute of Insolvency Professionals, as a judge for this competition. With over 20 plus years of professional experience, he brings extensive expertise in corporate security, taxation law, along with significant exposure to insolvency and regulatory frameworks. A registered insolvency professional and empaneled arbitrator and mediator under various statutory institutional mechanisms. His vast experience and practical insights greatly enrich the academic and professional value of this competition. We are privileged to have Mr. Vibhor Kapoor sir, Principal Associate at ACOM Legal, New Delhi, as a judge for this competition, with over 10 plus years of experience in dispute resolution and commercial litigation. He has developed significant expertise in handling complex corporate disputes across various judicial forums. Prior to his current role, he has been associate with reputed law firms such as Naik and Company and Vibhor and Rajni Associate Behar. He extensively worked on insolvency and bankruptcy matter as well as corporate litigation. His professional experience and practical insights greatly enhance the value of this competition. Now, I would like to start with a judge's briefing. This competition is a stimulation of corporate insolvency resolution process under Insolvency and Bankruptcy Code 2016. The teams will be acting as resolution applicants, presenting the resolution plan before you, who will be acting as committee of creditors. The problem of this competition is insolvency of DSDA Private Limited, a company engaged in manufacturing of electric vehicle battery, which has entered into CIRP due to its default in repayment of financial debt. The teams will analyze the financial distress, present a resolution plan, and help for the revival of corporate debtor. Each team will get 20 minutes to present their resolution plan before the committee of creditors. If required, committee of creditors can extend the time by 2 to 3 minutes upon their discretion. Each team will present their plan one by one in the room. After the presentation of each team, the committee members may ask questions to the teams regarding feasibility and viability of the plan, legal compliance under ITC, financial restructuring proposal, and the understanding of CIRP process. The question may be asked at your discretion in order to assess the team's clarity of thought, legal understanding, and practical approach towards insolvency resolution. Kindly evaluate each team using the score sheet provided to you with the rule book and the problem. Before filling the score sheet, kindly fill the team code on the score sheet. You are kindly requested to complete the score sheet simultaneously after the presentation of each team and submit the score sheet in your room after the presentation of all the teams. The evaluation parameters are based on clarity of presentation, viability and feasibility of plan, legal knowledge and originality. We also request all committee members to kindly provide constructive feedback to each team after their presentation. Your feedback will help the participant understand the practical functioning of the process and improve their approach towards drafting and presenting a resolution plan. A resolution professional has been appointed in each room to ensure that process is conducted in a structured and smooth manner and that presentation remain in accordance with CIRP framework. If at any point there is a technical issue or clarification required, the resolution professional or the organizing committee will be available to assist you immediately. Thank you, sir.
Greetings of the day. A very warm welcome to MAME's 6th edition of Justice J.S. VERMA Memorial ADR and Client Counseling Competition and Dept Law Fest 2026. Revival Quest, the Insolvency Resolution Plan Challenge mock CIRP happening for the very first time. We are very honored to have our committee of creditors in this room. We are highly obliged and welcome to you for this round. It is hereby humbly requested to our esteemed committee to kindly keep updating the score sheet. I, Saksham Pandey, will be serving you as a resolution professional. Initially, I was selected as an interim resolution professional and now promoted to resolution professional. So, ma'am, I will be assisting you with the maintaining the decorum of the room. The committee represented to please seek our assistance whenever it is required. Each side will get a maximum time of 20 minutes to present their argument. The committee may exercise discretion to extend the time of the round beyond the time specified for the rounds. The team code for the applicant is PC01. I would now like to seek the permission of the committee to begin with the round. Thank you. And now I request the applicant to start with the pitching.
Greetings to visitors.
Greetings to the honorable members of the Committee of Directors and the learned resolution professional, Mr. Dept. So today we have convened here before for a single statutory purpose, that is to determine by the application of commercial wisdom under section 30 of the code, the commerciality and the viability of this resolution plan, submitted by Eon EV Solutions Private Limited. So the objective of this proceeding is not liquidation, it is resolution. The preservation of the going concern, the protection of employment, the maximization of value of all stakeholders, and the restoration of commercially viable EV battery manufacturing. So the overview of corporate debtor is the Dept Private Limited is a company that is incorporated on 3rd April 2011. With over experience of over a later part of a decade, it has been engaged in manufacturing and assembly of electric vehicle batteries, lithium battery packs, and battery management system. The corporate debtor operates across the supply chain of EV battery manufacturing. So in this case, the CD has failed not because the business model has failed. It has failed because it ran out of a working capital. The OEM relationship subsists. The manufacturing capacity of 34.4 acres are still commendable. The environmental clearances subsist and the OEM relationships are ready to be restored. So this is an asset that works. It simply ran out of the oxygen. The corporate debtor's financial distress was primarily triggered by a single administrative action. That administrative action being a wrongful withholding of a INR 500 crore subsidy, which was first sanctioned and later withheld. So DSG, being the corporate debtor, had borrowed in good faith on account of the 500 INR crores. However, due to acute liquidity stress, the payments were deferred, credits could not be repaid, interest accumulated, and hence this petition. So this is exactly where we come in. The resolution applicant, being Xeon EV Solutions Private Limited, has also been in this industry for the later part of a decade. A registered office being at Aerocity, New Delhi. So we are not a distressed asset fund revival. We are not a financial acquirer. What we are is a strategic acquirer. What we aim is not to strip and sell. What we aim is to revive the business. We have the technology, we have the supply chain, and we have the distribution. We practically work in the same supply chain. We have the same product, same manufacturing, and the same OEM clients. We don't need a new learning curve. All we need is immediate operational viability. So in the financial year 2025, Xeon has recorded a revenue of 320 crores with an EBITDA margin of 14.1 profit margin. So this not only showcases our competency but our viability and feasibility for this plan. Our financial margins are not speculative. They are documented, audited, and available for verification. If the COC might refer to 4.3 of the resolution plan, it will find the financial statements for 3 previous years. So we operate in dedicated NMC and LPR battery pack assembly lines at the headquarter Manesar and Gurgaon. We have the same technology stack as DSC. And management team carries a combined expertise of 25 years of experience in the EV battery manufacturing. So we believe that upon resolution, we can transfer the R&D and the technical expertise to DSG in order to revive it and turn it around. So we hereby also declare that the resolution applicant confirms full compliance with 29A eligibility. We are not a willful defaulter. We are not discredited as a defector. No resolution plan has been disapproved on account of eligibility. We have no process in this case. So that brief of the financial plan, at the outset we propose a TRA of 75 CR that will be infused in 3 tranches. The first being So 114.91 is the total claims that were given. 114.91 was the total claims that were given and 76.06 were admitted. And the amount that we are paying is I'm sure.
I think 4.32 is the net amount that you are paying is 78 crores.
No, sir. Just So the grand total being admitted claims by the RP was 114.91. You can find it at 1.8 of the resolution plan.
Page number 6.
Page number 6. That is the summary that was provided to us in the information.
114.91.
Yes, information memorandum.
Excluding your CIR cost.
Yes, sir.
Yes, okay.
Can I continue?
Yeah.
So at the outset, the financial proposal proposes a total infusion of 75 CRs to be infused in 3 different stages. First, an upfront payment of 35 crores and 2 deferred tranches of 20 CRs each. My co-applicant will deliberate upon the financial proposal.
Honorable members of the committee, having presented to you the background of DSJ Limited, its cause of default, the credentials of Xeon EV Solutions as a resolution applicant, and the implementation schedule 1, I turn to the three parts, that is what precisely is being offered, how it is funded, and what is the commercial cause and case for revival. I respectfully submit that this presentation is not merely a recitation of financial statements, but it exactly explains why the resolution plan submitted by us represents the only commercially viable and legally compliant plan that is available. Coming on to the part 5 of the plan, the financial proposals. The TRA is proposed by Xeon EV is to be 75 CR. It is a complete and sole pecuniary liability of the resolution applicant as whole. The 75 CR is infused in 3 tranches, which is discussed further in part 6. I will come to that further. Firstly, on the order of priority, the CIRP costs are estimated to be around 3.5 CR, which is on the conservative margin. Secondly, we have workmen dues and employees, which are admitted to be 2.45 CR, and we have proposed a payment of full 100% to maintain the workforce and generate and to regenerate our operations and cash flows. Secondly, mandatory payment due to assenting financial creditors. This sequencing is not a choice but a statutory mandate under section 30 of the code. Payments to secured financial creditors are aggregated to be 32 CR to Axis Bank.
In case the payment towards the CIRP cost increases.
So we have taken a conservative amount. We have not been quantified CIRP cost by the RP as of now.
There's also an additional pool of 3.05 CR that is required for exigency circumstances.
So you will be pulling in additional funds from your end, or you will be basically diverting the funds from any other creditors pool to basically fund the.
Not from the other creditors pool, no sir. We are personally liable. The Xeon EV is personally liable from their balance sheets as well. It is mentioned in the plan.
That would be over and above.
Yes.
If
there is any over and above. But we have taken a conservative approach. 3.5 CR is an estimate on the higher side. According to clause 5.5, payment to unsecured financial creditors. Payment for clause 5.4, we have mandated an upfront payment of 12 CR, which will include 10 CR from the EMD. This distribution is pro rata, which is approximately Axis Bank will get approximate of 4.6 CR, State Bank will get 3.01 CR, HDFC will get 3.32 CR. The deferred tranche 1 after the month 18, when the operations shall be revived, we will infuse another 20 CR, which will be distributed pro rata to the outstanding secured financial creditors within 60 days. And the deferred tranche 2 will also receive 20 CR.
What is the source of funds for this tranche after 18 months and the 36 months?
So the sources are mentioned in part 6. Coming to the part 6, the sources of fund. Xeon EV shall offer total resolution amount of 75 through internal accruals of 15 CR of Xeon plus the 10 CR at EMD, and we have also taken ICICI Bank term loan of 20 CR, which will be infused within the 30 days of implementation date.
20 crores is come from
Term loans by
ICICI.
ICICI. Yes.
You have given EMD of 10 crores.
Yes.
That's
And another
30
internal
crores.
accrual of 5 CR will be paid by Xeon.
35 crores. That is your first tranche.
That is our first tranche.
That is your first tranche. But I am asking, what will be your source of funds? How will you generate? What is your plan after 18 months and the 36 months? So your second and third payment tranches start there.
Yes. So our plan, the 20 CR that are in deferred tranches 1, they will also be paid by Xeon EV through their own internal accruals as mentioned in our financial statements, and our estimated revenue which will be there, they will be paid from that.
So with respect to projections post revival of the DSA, we have made sure that the EBITDA margin that we have projected, which is 8 CR, 8.40 CR in the financial year 2026-27, as well as the operational, we have a 20 lakh per month. The corporate actor has a 20 lakh per month rental income. It also we also have 2 commercial clients that are already restoring the OEM relationship post resolution. The phases of implementation of the plan include restarting of manufacturing capacities as well as the facilities that we have at Gurugram. So that will also include the revenue that we get from there will also be included in the tranches in case that there is any shortfall. Even though the personal liability remains with us, but in the post-revival cash flows are present in the resolution plan, are accounted for.
So the funds of the resolution plan shall be implemented through a special purpose vehicle, a private limited company wholly owned and controlled by Xeon EV as an implementing entity. The SPV shall be incorporated and designated prior to the effective date after the committee approves the plan, and shall always remain eligible under section 29. The fund flow operates from Xeon infuses fund into SPV by the way of equity. The SPV shall deploy the upfront amount into the DST.
So, your entire second and third tranche payment, I understand the 35 crores you have already generated, you have everything in place. But your second and third tranche payment, as we understand, is basically from whatever you generate by the functioning of this entity.
So there's a
Not the functioning of DST, but from Xeon. We are liable to pay the total.
You are liable to pay, but your generation of funds for that liability
Yes.
is from DSJ starting functioning, and also the rental income that you are getting of rupees 20 lakh per month.
So it is a combination of both. In case that we are not, in case that there is any shortfall, DSG's operational revival cash flow is always a backlog. But Xeon has taken personal liability. We have taken personal liability of the amount that we have communicated for. 75 CR is totally tied up. There will be no case where the deferred tranche we are not able to pay. With a revenue of 320 crores and a net worth of 145 CR, we are confident that we will be able to pay deferred tranche 1 as well as 2. However, if there is any shortfall and our resolution plan being optimistic like that and the EBITDA margin being 8.40 crores for the financial year, we believe that the tranches will be compensated very wisely. We don't believe that there will be a financial problem with respect to our finances as well as DSG's post-revenue.
Okay.
Coming on to the part 7, the business plan and operational revival. I may now address the operational viability of the revival, which goes to the heart of committee's obligation under Regulation 38. The requirement that resolution plan demonstrate feasibility and viability and not merely assert it. Firstly, the domestic EV battery manufacturing sector is projected to grow at CAGR of 28% through 2030. Driven by accelerating two-wheeler and three-wheeler adoption, FAME-3 policy support and central government push for domestic cell chemistry under ACC and PLI schemes. DSG lost its revenue because it ran out of working capital and to procure raw material and to fulfill existing OEM orders, not because customers left it. The distinction is critical. A business that lost customer requires market rebuilding. But here, a business lost its working capital. It only requires capital restoration. Tranche 1 provides exactly that restoration.
How much are you paying to the operational creditors against their admitted claims?
So it is in annexure 2. We have attached an annexure of payments to all the stakeholders.
Page number?
Page number 67.
67.
Yes.
Second last page, that is. You can also find it in clause 5.
I don't find it over that the structured plan towards payment of the OCs at page 67. It's a payment schedule.
Yes, sir. 5.2 clause 5.2 categorically provides the amount that we are proposing to pay. So page 20 and 68.
20.
So 10 CR proposed payment as against 17.90, which is a 55.9 recovery. That is more than the liquidation measures.
So as mandated by the section 30 of CRP regulations, we will pay OC the higher of liquidation value or the priority payment under the total resolution value as under section 53. The proposed amount that we are paying is well above both of them.
So if you may please, there is a comparison of liquidation as well as resolution plan and annexure 1.
Annexure 1 is our own due diligence
Categorically
report.
revised.
It is our own due diligence report for providing liquidation value of the corporate unit.
Where is the next one?
So it's the first annexure.
Page.
Xeon EV solution is not a distressed asset fund looking to acquire DSJ at a discount and exit at very first opportunity. And on the optics, and the committee should care about the optics, a Xeon-led revival of DSJ sends a signal to every OEM customer, every raw material supplier, and every fleet operator in the sector that DSJ is backed by a credible operator and open for business. A liquidation sends an opposite signal. Customers that paused orders during CIP will be reinstated under Xeon's management because they know who Xeon is. We have already supplied a lot of them. The reputational bridge is something that no financial acquirer, no asset stripper, and no liquidator can build. Only we can, because we are already standing on the other side of it. I will elaborate this using 3 figures why Xeon EV is most compatible and efficient resolution application. Firstly, the procurement efficiency. Xeon's official existing bulk procurement network immediately extends to DSJ's raw material requirement. The estimated reduction in raw material cost under Xeon procurement is 8 to 10% when we are ordering in bulk. Secondly, technological continuity. DSJ's AIS type approvals, BIS certification, battery pack designs, and BMS firmware. Under liquidation, they will be of zero value. But collectively, its technologically portfolio remains intact under the resolution plan. Xeon's in-house R&D team working on next generation LFP and sodium ion cells integration shall be deployed to upgrade DSJ's BMS and battery pack configurations. Thirdly, the regulatory positioning. DSJ under Xeon's management shall apply for PLI benefits again, the FAME 3 incentives and the NCLT approval order under clause 11.9 constitutes DSJ's acquisition as fresh investment in EV battery segment, which entitles it to avail central and state government benefits as a clean entity. Therefore, we are also proposing a payment of government at 100% so that we are not in a we are eligible for FAME subsidies again. Every proposal is very prudently and commercially backed.
There is a reference to some SFIO proceeding. Can you elaborate on what are the SFIO proceedings and what is your steps to tackle those issues?
Sir, if the company
And whether any charge sheet has been filed by SFIO up to this
So
time?
there has been, the SFIO proceedings were initiated against the members of management with respect to diversion of funds and there was misrepresentation of compliance in order with the subsidy guidelines. There has been an investigation that has been launched by the SFIO with respect to the DSJ as a legal entity as well as the management. Certain members of management, that being Mandeep Singh and Rebecca Rana, that were also in management. So the present position is that only the investigation has been launched. I think it is the statute categorically provides that it is only aimed at investigation. If and when the charge sheet is filed and if and when the proceedings are initiated, what we as a corporate entity entail is the protection of 32(2)(a). That categorically provides that the liability of corporate debtor pre-ICD will not be transferred post-ICD. Post-resolution, our liability will cease to exist. The only liability that will not cease to exist is with respect to the erstwhile management. That being Mandeep Singh and Rebecca Rana and the authorities, that is an interstate dispute which the DSJ as a corporate entity has nothing commercially related to. We again will seek directions from the NCLT in order to make us eligible and avail subsidy schemes as my co-applicant mentioned, as well as to seize the proceedings with respect to 32.
Coming on to the later part of
But
operation.
what about the PUFE? The problem statement also says that the RP has already initiated the PUFE application. How have you treated the PUFE money if it will come back in the company? Then what is the treatment to that?
So there are two categorical applications as to 43 and 60C in the 66 aggregating to 17.5 CR in the amount. So the subsidies, first and foremost, the resolution applicant takes it upon itself to fight it with full rigor. It being a 17.5 crore being a substantial amount for the liquidation, we will fight it with full rigor. We will retain IBC and constitutional legal framework to file a counter affidavit for PUFE transaction and for recovery. The recovery, however, will be distributed entirely to unrelated financial creditors. There is no beneficial interest that the RA holds for the any recovery.
You will fight the cases on behalf of the RAs and the monies that which you will secure, that will be distributed among the residents.
Yes, the entirety of
the monies will be distributed among the financial creditors.
Yes. So the baseline comes from the fact that we are optimistic about the post-revival cash flow. We know that the investment that we are taking and the risk that we are taking is going to get our returns more than that we are investing. The CGR of EV battery manufacturing right now is 25 to 30%. With that investment, our investment will only grow. In relation to that, in order for the interest of all stakeholders, we are proposing that the secure financial debtors, which we could not pay 100% with the current value that we have, we are proposing that any subsidy recovery as well as writ petition recovery to the cap of 40% being 50 crores or 500 CRs will be distributed towards financial debtors. Any remaining amount will then be will be infused against to the operational credibility that will return to us eventually. That is the entire baseline of the resolution plan, that we will revive the corporate entity in order for us to profit in the later stage. If we were to take funds right now, the operational credibility and the operational amount that we can invest in the corporate data would be. That is the entire.
Moving on to operational viability, sir, I respectfully submit that committee is not choosing between this resolution plan and a superior alternative, because the choice between this committee is this plan and the which preserves going value concerns, reinstates employment. The choice before this committee is between this plan, preserves the going concern value, reinstating employment, pursuing the 500 crore subsidy litigation, and paying the creditors more than liquidation, which destroys all of the value permanently. DSJ's equity has already been eroded 14.40 CR in a single financial year, each month without resolution. Another month of irreversible value destruction will be there. The appropriate time for this committee to exercise its commercial wisdom and approve this resolution plan is today. The COC is also duty bound under the law that it must not only derive maximum value from the invested amount, but also uphold the objectives of the court, that is to maximize value, revive the corporate debtor, and offer a time-bound resolution.
So in view of the time, we now come to closing submissions. Honourable members, we return to the close of our submission. The question still pertains whether it is resolution or
Just
liquidation.
one thing before you close. Will the proceedings before the SFIO continue once your plan is approved or once any plan is approved? What's your stand on that?
So the resolution applicant's position being the same, that the erstwhile management is personally liable for the diversion and compliance of the fund. The misrepresentation was through the erstwhile management. The DSJ as a legal entity is protected under 32(2). Even if the proceedings do continue and we are ordered by the court in order to become a petitioner, and in the area of parties we have mentioned, in that case we will continue to fight it, because it is since the investigation is of serious tenure and will directly affect our governmental as well as other benefits that we want to avail. We will fight it with full vigor and tenure, but we still aim to get the benefit of a clean state doctrine that is also mentioned in Swiss as well as Manish Kumar versus Union of India. We aim to take that benefit. In case that is not provided or any exceptional exurgent circumstances come, we will fight it with full vigor. So can I continue? So the liquidation at an independently assessed net liquidation value of 61 to 65 CRs. We have already mentioned in Annexure 1 as we please the Committee of Creditors. The recoveries of government is zero. The unsecured financial creditors zero. Trade supplies and contractors zero. What we propose is a 55.9% recovery to OC or operational creditors, as well as 100% recovery to all the other statutory dues that otherwise would have been zero. So under this resolution plan, every creditor class is receiving more. The employees are paid on full in day 30. The government is paid in full day 30. We have two debt tranches, which means that within 3 years, all financial creditors as well as secured creditors will be fully paid along with the revenue. This is the best of both worlds. Zero EV solutions is not a speculative. We are not here for the assets like I mentioned before. We are here for the business. We are here to turn it around. We have the strategy, we have the technology, and we have the capacity. We respectfully pray that this honorable committee exercises commercial wisdom under section 34 of the code and approve the resolution plan submitted by us. In the interest of creditors, employees, and the going concern, the committee has the power to preserve it.
The judges are hereby requested to please provide their valuable feedback to the participants.
So if the committee can please please control the extension of that.
What is the treatment that you are giving to the dissenting financial creditors in this case?
Sir, the dissenting financial creditors will not get not less than what we will be entitled under the liquidation.
And at what stage are the payments due to the dissenting financial creditors?
Sir, they will be in priority to dissenting financial creditors and pro rata to the workmen and employees.
Okay. So as per you, the waterfall mechanism will start with the payment towards the CIRP cost, and thereafter the workman dues and the statutory dues, and then along with that the payment to the dissenting financial creditors. If any.
The difference here lies between pro rata and upfront. The other creditors are getting it upfront, whether dissenting financial creditors are getting all the payments upfront. OC is getting it in deferred payments. The payment being the same, just the timeline is different.
My only concern is that the payment that you have structured for 18 and 36 months, that primarily depends on the revenue generation by you as the entity, as the SRA, and the revenue generation by the CD. So how you will structure and secure that payment, that is not coming out very clearly in the plan. because that may actually work against you when we actually weigh other plans against your plan.
So mainly the 20 CR are coming from Xeon's internal approvals, and it has nothing to do with DSG as of now. If there is
Xeon's internal remuneration or Xeon's internal funds will also depend on your revenue generation and everything. So that somehow makes the plan contingent. So whether a contingent plan is a plan which can even be approved.
So it is not a contingent plan, as we already have our suppliers, we already have our customers, and contracts are already been signed in advance. We have projected cash flow which is going to come, and therefore we are paying 20.
Projected cash flows are not actual cash flows. So that is something that will make the plan contingent. Can you tell me why will we not consider this plan as a contingent plan, and whether a contingent plan can ever be allowed by the NCA?
So not a contingent plan that truly depends that the whole total resolution amount is contingent. But as we've said, the DSJ's operational revival was only based on working capital, which we are providing in tranche 1. The tranche 1, the operational revival will start from month 18. That is.
And when are you paying the OCs? OCs you are paying X plus 60 days.
Yes.
If X plus 60 days that you are paying, then how will you instill confidence in those operational creditors to start giving you the raw material or whatever you need till the time you give them the money, because they are basically after the money.
Sir, that is the baseline being that we have been in business for 15 years. In the practical sense that we have been in business for so long. Insolvency does hamper the regulation with respect to the business operation, but we have consistent supply of OEM relationships that are ready to be restored just directly after resolution. We have two commercial clients. The phasing, as my co-counsel mentioned, is the starting of one manufacturing plant. The manufacturing plant is monthly, the annual turnover is 15 to 18 CR. With that projection of 15 to 18 CR, which is not a projection, which is directly manufacturing of 12 to 15 units of an EV manufacturer to the month of manufacturing capacity that has 120 megawatts of capacity, it automatically turns to 15 to 80 CR per month revenue generation. That is not projection, so that is a simple math.
So we have very comprehensively in clause 7.4 and 7.5 the revival phases and revenue projections are given out. So phase 1, we have stabilization and restart from month 0 to 6. The immediate priority, we will physically restart at least one of the assembly lines at the Gurugram facility, reinstating the core staff and restoring raw material credit, which we have already established from Xeon's own raw material suppliers, even at a discounted rate, which will further.
Have you taken into consideration that for the workforce and everyone that you employ in phase 1, what will be your output? Because what I see in the second paragraph 7.4.1, by the end of months in DSJ targets achievement of production of so and so per month on a single shift basis, generating monthly revenue of approximately 4.5 to 5.5 CR, sufficient to cover variable operating costs and contribute to fixed cost recovery. So how do you determine what will be your variable cost for generating this kind of revenue?
So as we have already seen that we have not been given defined salaries of the employees and other costs, but in the mood problem, the corporate debtors particulars, we have seen that the liabilities from employee benefits, from finance costs, from cost of raw materials are aggregating to a total of 52 plus 18 plus 14 CR yearly, which will be covered well within the operational surplus, which will be managed by both Xeon and DSJ as well.
You can find these expenses on page 15 or 68. Page 15.
From the already given matrix, we are speculating the cost which will arise out of the generation and operational turnover. I would like to apprise the committee that we have a very detailed projection and revival phase in the clause 7.4 and 5. And it is not merely a projection, but because we are in the business and we know how to turn around, we will do it.
I request the participants to kindly leave the room. And would request the committee to kindly take the source sheet to So, ma'am, with your permission, shall we call the next applicant? Thank you. The team code for the applicant is TC06. 2 minutes.
Committee of Directors and the resolution profession, I stand before you today not merely as a bidder, but as a strategic partner with a singular vision to transform DSJ Private Limited from a stalled, distressed unit into a cornerstone of India's EV revolution. I represent Nexus Mobility and Energy Solutions. We are a public limited company with 15 years of institutional memory in the automotive sector. To understand why we are the right fit, we must look at our footprint. We hold 25% of the domestic EV manufacturing, and in EV battery pack supplies, we operate 3 global R&D centers. We don't just assemble batteries, we design the power electronics and the battery management system, which drive them. DSJ failed according to 3 specific reasons. First was the breach of localization norms, which resulted in a liquidity crunch and the legacy management issues. We solved all 3. We are already PLI and FAME 2 compliant. We have the Made in India certification, and by integrating DSJ's 34.4 acre facility into our existing supply chain of 200 plus vendors, we bring immediate credibility back to this asset. So, when we examined DSJ's financial statement, the story was clear. This wasn't a failure of demand, it was a failure of structure. The company was crushed under high interest carrying cost and sudden withdrawing of rupees 500 crore subsidy. So for our operational strategy to revive this company is first of all retooling for resilience. We are not keeping the assembly lines as they are. We are investing our own capital to retool these lines. This allows for flex manufacturing, which means the ability to switch from 2-wheelers to 3-wheelers on the same line. Our second would be vendor managed inventory. One of the biggest drains on DSJ's cash flows were raw material procurement. So Nexus Mobility will implement a VMI model. Because of our scale, our vendors will hold the inventory at the DSJ site. This means DSJ won't pay for parts until the moment they are required on the sites. This effectively solves the working capital crisis without requiring massive new loans.
Can you tell us that have you been in talks or some kind of discussions with such raw material suppliers who will give you that benefit? Because once you keep they bear the burn of products or the raw material being kept at your site, and with tomorrow if someone takes away that raw material or that there is a damage to the raw material, then who will have the onus? How will you ensure that the supplier will keep that onus with himself?
So, I believe that as a market leader, we already have similar, in the EV sector only, we have similar suppliers. So we have all...
where have you explained that in your resolution plan?
So, in our profile of the resolution applicant, we have explained that we have a presence in global electronic vehicle and battery energy storage system markets.
No, but your statement that you have such kind of tie-ups earlier, I don't see that. Where raw material is supplied and kept at your site at the cost of the supplier.
So that may not be mentioned here, but we have those tie-ups and we have the trust that already in the market. So, as the market leader, we also have the leverage with the cost-cutting measures with the suppliers.
One more thing, you propose management of revival strategy.
Yes, sir.
You say that you will constitute a legal strike team.
Yes, sir.
And here you say that we will propose a success fee based legal model to keep costs low during the initial revival phase.
Yes, sir.
So can you elaborate on that? You want to file that writ petition for 500 crore subsidy which has been according to you illegally taken.
Yes, sir.
So can you explain that what is success fee based model even permissible in India?
So, yes, sir, it is permissible, and it will be done accordingly to the subsidies that will be granted to us. We will ensure that the localization norms are upheld and we are compliant with the policies, and the legal team that are going to help us in achieving that.
Have you sought any proposals for any such kind of success fee model with anyone?
So we are already in talks, but we have not finalized the legal team yet.
Success fee model I don't think works in India. It's not permissible.
So
I think for this also you will have to either rework the plan or we cannot consider it completely compliant.
sir, I will rework on the plans for sure, and I will see if we will remove the success fee based legal model if it is not okay with
Then
the-
that you will have to somehow adjust that in your cost because that cost will come.
Sure, sir.
Okay, continue.
So, alright. So our business and operational plan, the immediate actions will be conducting an internal audit of all 200 plus domestic vendors to create a localization dossier. This is presented to the Ministry of Heavy Industries to seek in principal approval for the release of the subsidy. We will be restarting the operation, focusing on fulfilling the existing domestic OEM contracts that were stalled using a pay-as-you-go model for raw materials to ensure no further debt is accumulated. As per our long-term strategy, we will transition from a product selling model to a leasing model for logistic fields. This provides the company with steady and predictable cash flows instead of volatile sales. As per our financial proposal, it is built upon the principle of certainty today and upside tomorrow. The total commitment is of rupees 57.5 crore base plus variable success kickers. An upfront payment of
Variable
rupees.
success stickers, can you elaborate on that?
Sure, sir. So, sir, we are guaranteeing 100% of the POFE transaction recovery to.
How can you guarantee that? That's a case which is subject.
It is contingent, so that's why it is written that.
Do you think that contingent plans can ever be approved? Because your 57.5 crore being base plus rest of the money is completely contingent on your recoveries of 17.5 crores.
Yes, sir.
But that's a contingent plan.
Yes, sir.
If tomorrow you lose that battle in NCLT,
Yes, sir.
even in appeal, then what is your recourse? How do you pay back the money?
So first of all, we are guaranteeing the 57.5 crores base, which is way more than we can expect in the liquidation of the land and the assets of the company. So that is guaranteed, and we are also ensuring that through our legal process, we claim the rupees 17.5 crores from POF transactions and the rupees 500 crores subsidy. In our plan, we have promised that if we receive the 500 crores subsidy, the 75% of the net recovery to the cap of.
Let's come to your distribution.
Sure, sir.
Your distribution says secured financial creditors amount came at 76 crores. You are offering 38.45 crores.
Yes, sir.
Out of the 38.45, your base recovery is 57.5.
So
Enhanced by 100% of PO transaction recoveries. And 75% of the subsidy success quicker. Can you explain this?
yes, sir. So, sir, first of all, the 57.5 crores are distributed among all the, according to this particular table. The rest of the debt, out of the 76.6 crores, 76.06 crores, will be distributed by 100% of the PUF transactions. And if the subsidy is allotted to DSJ, the 75% of which will be given to the secured financial creditors, and up to the fulfillment of the debt.
And what is the treatment in case the CIRP cost goes beyond 2.5 crores?
So in case it goes beyond 2.5 crores, it will be paid from the pocket of Nexus Mobility.
Where have you explained that in the plan?
So that is not given.
Okay. And out of, so you are saying how much you are paying to secured financial creditors in the upfront payment?
38 in the upfront payment.
17.5 crores.
Yes, sir. Yes.
To be paid, this provides immediate liquidity. 17.5 crores includes your CRP cost also
Yes, sir.
of 2.5. So you only pay 15 crores out at in upfront stage to the secured financial creditors. This is this includes CRP cost. So it's only 15 crores. And at upfront stage, you are only paying secured financial creditors.
Yes, sir.
But if there are any dissenting financial creditors, then what is the treatment that you will give to them?
Sorry, sir.
If there are dissenting financial creditors, what is the treatment that is envisaged in the plan for them?
So for the dissenting creditors, we are offering the deferred payment of INR 40 crores, which will be distributed in equal installments of 10 crores each year, which is
That
few.
40 crores is part and parcel of the complete amount which has been offered.
Sorry, sir.
This 40 crores is part and parcel of the total commitment. It is not represented in financial statements.
That's deferred payment. Sir is right. Deferred payment is INR 40 crores.
But payment is only the schedule is being proposed.
Yes.
How that payment will be made.
Yes.
It is not attributed directly to dissenting financial creditors. So there is no treatment to dissenting financial creditors in your plan. Unless you show me somewhere else, from what I can gather, there is no treatment to dissenting financial creditors.
So there was a reference of SFIO investigation timing.
Yes, sir.
So where you have dealt with it?
So in the implementation,
Anything related to SFIO in your...
sir, in the implementation timeline, in T plus 60 days, we will.
Which page?
So this. So in T plus 60 days, we are immediately filing for an application under section 32A to obtain a clean slate order shielding assets from SFIO attachment. This clean slate doctrine is our legal shield, and it ensures that the 34.4 acres of land and the assembly lines are protected from the attachment for the crimes of the previous owners. Furthermore, we are forming a clean entity to take over the assets the SFIO can and should continue to pursue the old promoters. We have even assigned the 100% of the PUFE recovery rights to the banks to assist in this. But the factory and the workers must be allowed to move forward without the taint of the past.
So whatever you recover will go to the bank.
Yes.
But you will at least cost for what the recovery.
Yes.
And what is your payment timeline to the statutory dues and operational creditors?
So, within 4 years, we will complete all the payments to the creditors, and as per the section 30, our plan provides for the payment of insolvency resolution process cost in priority.
So you will pay CIRP cost out of that 17.5 crores upfront,
Yes.
and you will also pay workmen and employees of 2.45 crores upfront from that.
So the workmen and employees, yes, sir, they will be provided 2.45 crores.
Then whatever is left will be used to pay.
The secured financial creditors.
So the upfront payment to secured financial creditors is somewhere around 13.5 crores.
Yes, sir.
We will have to see how secured financial creditors will ever be satisfied with such a small upfront payment and the structured payment of over 4 years.
So, in case of liquidation, the secured financial creditors will have to wait for quite a few years. They will have to auction the property and assets of the company, and if the upfront payment is still better than that. And also, in the deferred payment,
Council, we are not only considering liquidation value, we are also considering the viability of your plan vis-a-vis the viability of other plans that we have also received as committee. So we will have to be fair to everyone. More so, your plan looking a little contingent on your recovery of the QFE transactions and everything will make it very difficult for us for this to even pass the NCLT, because NCLT, can you explain what is the law with respect to contingent plans? Is contingency in a plan considered, is NCLT allowed, not allowed to even consider that issue, and it falls within the framework of wisdom of COC?
so I'm not aware of that. But so, talking about the other plans given by the resolution applicants, we are not, our whole plan is not contingent. The payment that we are guaranteeing is 57.5 crores, and the 40 crore deferred payment is also not just fueled by the operations, but also the 2.54 crores according to the financial statement of DSJ are received from rental incomes. So that out of those 10 crores, 2.4 are already available readily. And the rest will be fueled by the operations, as I suggested in our operation plan.
Okay. Continue.
So, after the talking about the implementation timeline, there will be a payment of 100% CIRP cost and first upfront amount. Then after T plus 60 days, we will immediately file an application under section 32A to obtain a clean slate order shielding assets from SFIO attachment. In 120 days, the retooling of assembly lines and certification of 100% localization to the Ministry of Heavy Industries. In 4 years, there will be staggered payments to creditors and active litigation for the 500 crore subsidy. talking about our own legal compliance, I confirm that I have no connection to the existing promoters, Mr. Mandeep Singh or Ms. Rebecca Rana. My entity, its directors and connected persons are not undischarged insolvents, willful defaulters or disqualified under Section 29A of the IEC.
Council 29 compliance is fine. Anything else that you want to elaborate?
Yes, sir.
There is only 1 minute.
Yeah, we can.
Sir, as per our own research, the debt service coverage ratio is projected to be 1.45 by the year 2, and which is 45% more cash than needed to cover the annual 10 crore rupees investment. Also, the current collection period of DSJ Limited is 90 days. We are aiming to move it to 45 days by securing deals with our existing suppliers. Also, we are aiming for a current ratio of 1.5 to 2 and an EBITDA margin of 15%. The distribution, I would like to clarify, is based on the IBC priority liquidation benchmarks and viability of the resolution plan. Secured creditors are prioritized due to their risk exposure. Unsecured unsecured creditors are also fairly treated, and the subsidies are not used for payouts as they are not as they are used for development and survival of the business. Yes.
Thank you. Thank you. The judges are hereby requested to please provide their valuable feedback to the participant, if possible.
I think your plan had a few things which were missing. Like we actually asked you those questions. I think that's clear that way. The treatment to the second financial creditors is not there. Sir also asked about other creditors. That is also something which is missing. You may have a thought about it, see how you want to place it, but that should also come in your in the written document. Because when the committee sees what is on the paper, and the voting will happen only based on what is there on the paper. So this plan, if not at this stage, may actually be asked you to basically ratify and make those changes in the plan. So that is what I believe my inputs are. You had a clear thought about it, but that was, I think, not reflecting somewhere in the plan.
At the same time, it is not only the presenting before COC. Ultimately, you need to defend it before the NCIT, and there might be many more questions about it.
Yes.
So one has to prepare for the NCIT, right? So there, the plan which you have submitted should have each and everything in detail.
Yes.
What would be the thought process and how you are going to meet out those criteria.
Like the question for contingency is very commonly asked if the NCIT takes a whiff that this is a plan which will be contingent, then that is very much within their prerogative to question that and return the plan for reconsideration. So you will have to work on that as well.
Sure, sir. I request the participant to kindly leave the room.
Thank you.
And would request the committee of kindly to fill the score sheet if you have. Sir, with your permission, shall we call the next applicant? Okay.
टी कॉफी यहाँ पर कोकोनट वाटर भी रखा है बहुत नॉट टी
But without sugar.
So, with the permission to stand for the next application. The team code for the application is TC22. I would now like to seek the permission of the bench to continue with the argument.
Yes.
Thank you. Now I request the applicant to start with the
A very good afternoon to all of you members of Committee of Traders and the Resolution Professional. I appear on behalf of PC22 as the resolution applicant for the corporate insolvency resolution process of the DSJ Private Limited Company. What lies before this committee today is not a choice between a good outcome or a bad one. It is a choice between preserving value and permanently destroying it. DSJ Private Limited is not a failed company. It is just a distressed company, and that distinction is critical. A failed company has no viable future. DSJ does. It has operational infrastructure, a proven revenue base, and a product aligned with one of the fastest growing sectors in the Indian economy. What DSJ has suffered is not a collapse of business, but a disruption caused by a specific identifiable and an invisible event. And that is precisely what we are here to fix. Now we will talk about the part A, which talks about the resolution, about who we are. PG22 appears before this committee as a resolution applicant with a complete and detailed understanding of DSJ financial position. It is a CIRP timeline, its litigation exposure, and its operational capabilities. Our proposal is firmly grounded in the legal framework of the Insolvency and Bankruptcy Code, including Section 53, waterfall mechanism, and Section 29A, eligibility requirements, and the mandatory conditions. We are not here to strip DSJ of its assets or extract a short-term value. We are here to revise the value and address the going concern, because that is the only approach that maximizes the value for every stakeholder in the room. There are five concrete reasons that justify the resolution plan. First, DSJ has actually tangible assets which are verifiable, and the asset base is approximately 151 crores, including the 58 crores in the plant machinery and 34 crores in the recoverable receivables. These are the real operational assets. There are no speculative claims. Second, DSJ has 3 fully manufacturing facilities located in Gurgaon, Greater Noida, and Zirakpur, covering a total of 34.4 acres. These facilities are already built and equipped and are capable of immediate restart. There is no additional capital or any kind of investment required to set up it. Third, DSJ operates in electrical vehicle battery sector, which is one of the strongest structural growth and supported by the government policies and has an increasing market demand. Fourth, DSJ earns a stable rental income, which is a great point because it will help in generating 20 lakhs per month of revenue from XYZ Private Limited, which ensures a consistent baseline cash flow even during the initial stabilization phase. Fifth is a pending subsidy rate petition before the High Court that represents a potential recovery of up to 500 crores. The value exists only if DSJ continues as a going concern in the event of liquidation. This opportunity is extinguished entirely. These are not projections. These are the existing advantage, and they must not be lost. Now you will understand how DSJ actually went there. The real cause is DSJ Private Limited was incorporated in 2011 and entered into the EV battery manufacturing sector in 2018. The company expanded rapidly by establishing manufacturing facilities, entering in OEM agreements, and building operational capacity. The expansion was financed through debt from Axis Bank, State Bank, and HDFC Bank. The repayment model was dependent on the government-backed EV incentive subsidies. In 2022, the government withheld the subsidies amounting to INR 500 crores, alleging that DSJ has failed to comply with the domestic localization norms by importing battery components instead of sourcing them domestically. The single regulatory action disrupted DSJ's entire financial structure. The absence of expected subsidy flow led to immediate cash flow constraint. Debt servicing became unstable, vendors' payments were delayed, OEM customers lost their confidence in us. The series of fraud investigation initiated the proceedings. Revenue declined from 112 crores to only 86 crores. Subsequently, Axis Bank filed a petition under Section 7 and the NCLT admitted the matter on 18 September 2025, initiating the CIRP. Now the critical point is DSJ insolvency is not the result of a flawed business model, it is the result of an operational incompetence. It is the result of the single external regulatory disruption. The distinction is decisive because the broken business cannot be revived, a disrupted business can be stabilized, and that is exactly what our resolution plan achieves. The localization issue is currently under challenge before the High Court. However, our plan do not depend upon the litigation outcomes. We address the root cause directly by implementing full domestic localization compliance within 90 days, ensuring that the issue does not arise again. The key financial position as of the 31st March 2025 is the total asset holding is 151 crores, total admitted claims is 114.91 crores, revenue of financial year 24 was 112 crores, and the revenue of financial year 25 is 86.5 crores. The financial cost is 14.1 crores and accumulated loss of only 22 crores. These figures clearly demonstrate that DSG is under financial stress, but it remains an operational and revenue generating business. Our main step, the step we will take on the first day is that we will immediately change the board. Upon the arrival of the resolution plan by NCLT, the existing board of directors will be removed entirely. Mr. Mandeep Singh and Ms. Rebecca Rana, both of whom are currently subject to SFIO proceedings in their personal capabilities, will cease to have any involvement in the management from the DSJ from day one. This step is very essential. First is ensure the eligibility of the protection under section 32A of the code. Second, it restores the confidence among the OEM customers and market participants. Third, it establishes a clear and credible break from the past government's issue. You can also refer to page number 4. It has a table on it which tells about the incoming management structure. A new professional driven management team will be appointed within the defined timelines. Management director, a minimum 10 years of experience in the EV manufacturing, appointed within the 30 days operational authority. CFO, the chief financial officer, a restructuring specialist responsible for creditors, reporting and financial discipline, appointed within 15 days. Chief legal and compliance officer, dedicated to handling the SFIO proceedings and the subsidy litigation. And
where on the card? So those people would be you joining or you would be transferring it from your own organization?
No sir, we won't transfer from our own organization. We will hire
those would be on deputation to the village.
Those who will be hired would have a great reputation in the market, and we will poach them from different companies. Now I would like to move towards the employer retention, that all the existing employees, including the workmen and technical staff, will be retained. All employees' dues will be cleared within 30 days. The existing workforce represent operational continuity and institutional knowledge, both of who are critically for immediate revival. Now the revival plan, you can refer to page number 6 and page number 7 for detail. In the operation plan, we have divided into 3 phases. The phase 1 is the stabilization phase, which covers from the month 1 to the 6 months. The Gurgaon manufacturing facility will be restarted within 45 days. Revenue generation will resume and receivables amounting to 34 crores will be mobilized as working capital. OEM customers will be re-engaged within 60 days through new management representation and revised contractual assurance. Domestic localization compliance will be fully implemented within 90 days, eliminating the root cause of the subsidy dispute. In the phase 2, we will focus on the growth. Phase 2 will be off from the 6th month to the 18th month. The Greater Noida facility will be progressively brought back into the operation. DSG will expand its storage and business, diversifying revenue streams beyond OEM dependency. New OEM supply agreements will be executed. Revenue is projected to stabilize from 75 crores to 90 crores, with the company achieving EBITDA positive. In the phase 3, we will try to move towards the sustainability from month 18 to the 36 months. All 3 manufacturing facilities will operate at its full capacity. Revenue will scale from 120 crores INR to 150 crores INR. A 6-month working capital reserve will be established. DSG will reapply the inclusion under applicable EV intensive schemes the time with full compliances. The company will emerge as debt stable, profitable and hopefully debt free. For the financial projections, please refer to page number 12, which tells about the year 1 revenue will be 75 crores, year 2 revenue will be 100 crores, and year 3 revenue will be 130 crores plus. This demonstrates that the plan is grounded, and we hope to see the optimistic projections of the plan. In the structural improvement, the resolution plan incorporates long-term corrective measures, full domestic localization compliance to eliminate any regulatory risk, outcome based upon the supply contract
contracts to improve receivable recovery, optimization of underutilized assets, including partial of the zero-put facility in contract of manufacturing capacity. These measures ensure that the issues leading to insolvency are not repeated. Now in the closing, I would like the honorable members and the committee is not being asked to take a leap of faith. You are being presented with clear structure and legally plan that preserves the value and restores the operation and maximize the recovery. Liquidation is irreversible, resolution is still recoverable. DSJ has the assets, the market and the capacity to operate. What it requires is intervention, and this is exactly what our plan provides. The decision before you is not complex, it is a decision between losing the value today or rebuilding it for tomorrow. I would also like to state that the DSJ capital was a little more optimistic than it should have been. So, but still, we are here to see a hopeful future for them. Now, I would like to invite my colleague. He will present now the financial proposal, including the distribution to creditors and the legal framework that ensures full compliance with the insolvency and the bankruptcy code.
Good afternoon, committees of creditors. I will present the part B and part C of this plan, and I will present in a short manner and in the main pointers. So basically, the first point is regarding the total amount we are offering. So we are offering 75 crore rupees against the liquidation value of 60 to 65 crore rupees. So our plan has 15 crore more than a liquidation value. And the second thing is regarding that how will we pay. So the 75 crore rupees out of 40 crore is paid upfront within the 45 days after the approval from the NCLT. The upfront payment is unconditional. It does not depend on any production milestone, any revenue target or any court outcome. It is paid because the plan is approved, full stop. The remaining 35 crore rupees we will pay in two installments. The first installment will be paid after 1 year, 12 months from the EBITDA of the company, which is around 10 to 12 crores, and we pay around 15 crores in first installment.
You are saying that your first 35 crore, first 40 crores is without any other, so it does not depend on anything else.
Like some court, we have also filed a court case in the court regarding a 5 crore dispute and a few proceedings.
But if you see your upfront payment section in para 5, it says internal sources of resolution applicant team supplemented by recovery of DSJ's own outstanding trade receivables.
Yes, sir. We are not
and other financial receivables aggregating to 34 crores.
So basically, this upfront payment is not from the operations. We are especially targeting the earnest money deposit and the outstanding receivables. So basically, the upfront payment is from the
outstanding receivables. If you don't receive that money in time, because you have given very aggressive timelines. As per your timeline, CIRC cost will be paid in 7 days of approval.
Yes, sir.
And that is inclusive of 40 lakhs is inclusive
40 crores
of 2.5 crores.
So we are trying to get the receivables. We start legal proceedings against the receivables to get the receivables.
These two things are contradictory. You could see.
So basically, if the receivables do not agree with us, we initiate our internal funds also to complete this. Our first commentary regarding the upfront payment. Our first commitment.
Your commitment doesn't come forward that how will your internal sources, how much of your internal sources which you engage to recover to pay out this 34 crores. I understand you are paying 40 crores, out of the 30 crores is already with us with an EMD. Apart from that, you have to get at least 30 crores amount.
Yes, sir.
30 crores you have to secure from somewhere where your entire basis of that 30 crores seems to be your recoveries. Within a period of 30 days or even 60 days for that matter, for you to ensure recoveries and ensure timely payment to the creditors, because these are all FCs, the payment in your first tranche according to me is only FCs.
Sir, we don't have any kind of disputes going on with the creditors.
But at the same time, your proposed hiring would take at least 30 days. And
Exactly, sir.
within those 30 days, you need to hire the people and you have to recover the money as well. hiring has to be done first, then only they would initiate the process of recovery.
Who will take up the process of recovery, as sir is pointing out?
Till that time.
Sir, our own
These two
existing
things are
management.
going hand in hand, contradictory to each other.
Sir, our existing management will recover this upfront payment and
Existing management
of our company as a resolution applicant.
Of the RSC.
okay.
But my other thing is that your initial payment, upfront payment itself is completely contingent on recoveries. If you don't recover, you don't pay. So then the problem for me as FC, because I am the SRA, all of us are SRA as FCs, we will never approve a contingent plan because we know NCLT will never approve a contingent plan. Why should we approve it?
So, basically we are also playing a little optimistic here that the recovery will be quite fast and there will be no disputes among the creditors or any kind of other.
But that is only an apprehension.
Not apprehension, sir. Otherwise,
More than an apprehension, this is legally unviable. Legally, it is not permissible for you to hinge upon only. I cannot approve a contingent plan.
so if this doesn't work out, if the creditors doesn't pay money, we will definitely try to infuse our own money. The company, we will infuse our own money, and then or we will just lend some money to the same company on papers, and we'll take back the money once the recovery is done.
That declaration or undertaking has to be there on the process.
You include it.
Okay.
The next point is how the money is distributed. I want the committee of creditors to please refer to the page number 9 and 10, where we have a table which clearly indicates how amount is claimed, how much we are offered, and recovery, how percentage of recovery is there, and payment timelines. We have the total admitted claims is regarding 114 crore and 91 lakh rupees, and total amount we are offering is 75 crore rupees. This is almost 65% recovery, approx 65% recovery. And the most important point is the Zenith Urban Holding. We are not going any amount to Zenith Urban Holding because it is connected to the Horizon Urban Holding, which is the 25% of the DSG promoter shareholding. This makes Zenith a related party transaction of the corporate debtor. And the section 21 of subsection 2 of IBC code excludes the related party from the committee of creditors and from any recovery distribution. This is a statutory prohibition. And we have no legal authority to offer recovery from related parties, even if we want it. The court does not permit it. And the next one is the protection for the creditors who vote against our plan. If the dissent creditors vote against our plan, our strategy is to, like we have upfront payment of 40 crore rupees. We will receive 5 crore rupees from this payment and try to distribute among the dissent creditors. If we don't get it, we indulge our own fund of 5 crore rupees to give to the dissent creditor to satisfy them that they are getting about the liquidation value. And the next part is part C, legal compliances and declaration. Our eligibility under section 29 of IBC code sets out the eligibility that we are as a resolution applicant must satisfy. We are not an undischarged insolvent. We have not declared a willful defaulter by any bank or financial institution. Our accounts have not been classified as non-performing assets for more than 1 year. We have no conviction of carrying of imprisonment of any offence for 2 or more years. We have not debarred from the market by SEBI. We have not given any personal guarantee for DSG debts to any creditors. And we have absolutely no connection with Mr. Mandeep Singh, Ms. Devika Rana, Horizon Urban Holding LLP, or Blue Creek Realty Investment Private Limited. And DSG's promoter or related party. Our eligibility is on the section is clean and out. The point 2 is the compliance checklist under section 30 subsection 2 of IBC code. The section 30 subsection 2A corporate, we are playing the corporate insolvency resolution process fees fully within the 7 days once the NCLT approves this plan. The section 30 subsection 2B treatment of operational data, we are paying 100% to workers and the employees of their admitted claims within 30 days. Government dues including GST, Provident Fund and all statutory dues receive 100% within 90 days. So raw material supplier and contractor receive 6.5, which is of the estimated liquidation value. And section 30, subsection 2C, protection of dissenting creditors. Any creditor voting under this plan receive not less than the liquidation value, and we will try to receive additional of 5 crore rupees has been reserved for this purpose. And section 30, subsection 4, commercial wisdom committee creditors. We fully understand and respect that this committee has a final ability to approve or reject this plan to in exercise of this commercial wisdom. That this authority is yours. We are here to earn our approval, not demand for it. And the part. And now,
what is your treatment to the OFA applications and the SO5 proceedings? How are you treating them?
Sir, first I want to discuss about the SO5 proceedings. Sir, as we change the management, already we have engaged for the new management. As per the section 32A of insolvency, bankruptcy provides a clear answer to this concern. When two conditions are satisfied, the company receives complete immunity from the SFIO proceedings act committed before the insolvency commenced. Condition 1 is the resolution plan is approved by NCLT and a complete change management take place with all director removed. As we already try to change the management, so these both conditions are satisfied. And regarding the proof transaction, we had decided that once we get the amount of proof transaction, we will distribute to the creditors. And also the 500 crore restriction if we get, we also distribute to the creditors to satisfy them. And
Entire 500 crores.
no sir, entire we will discuss when we get. We will distribute as per the basis we have decided to the stakeholders.
But again, that is based on the contingencies.
So this plan sir is not.
We will sign a future contract with the lenders that if we, because benefit is not guaranteed, so if we win the subsidy case and we get the 500 crores, the first thing we will do is we will, we are not giving all the money to the banks in the early stages. So we will try, we will clear all the amount, all the pending amount. With interest or without interest, we will discuss it further. And we will all, and the plan, the registration plan also states that now the company won't depend on subsidy. Because perhaps because of this, they were too much optimistic on the subsidy amount that they didn't focus on the other financial parts. So what we have decided is that when we acquire this, we won't depend on the subsidy. Subsidy will only be a benefit in the future plans. And of course, we will invest that amount into it and we will infuse the capital.
And lastly, I want to call my speaker one to give the closing statement.
Members of the committee, let me close this. What is ultimately a simple choice. Liquidation gives a value of 60 to 65 crores and spread over a prolonged period of time with the complete destruction of DSG going on and a permanent job loss. And most significantly, the death of the 500 crore subsidy case, or we can say the petition, because that petition only survives if the DSG survives. The plan gives you 75 crore as guaranteed base, fully disbursed with 24 months, and with the petition alive and actively pursued to a renewed business generating employment and contributing to India's domestic EV supply chain, and the contingent upside that could transform the creditor recovery beyond 65%. DSG is not a broker company, it is a company that was hit by a specific external regulatory shock.
Time is over.
No worries, please continue.
So basically what we are asking committee to exercise is commercial wisdom in favor of the revival, because every financial metric, every legal standard and every stakeholder interested in this point the same direction. And we would be more than happy to serve the creditors and revive this company and make a better future of it.
The judges are hereby requested to please provide the valuable feedback to the participant if possible.
I think there was clarity. The only thing is that once we started asking questions, you were a little basically taken aback. So you have to gather your thoughts. You can take a minute and then respond. Just don't need to rush into a response. Have the time. And so that is why I'm saying just, and when you're making a plan, because what we gather from this is that treatment, especially to how have you treated the unsecured, the dissenting financial creditors and all these things, basically the questions that we posed, वो बहुत clear नहीं आ रहा है इस plan से. That is where you need to work. Other than that, it was good. It was good for you to, which year are you in?
Sir, third year.
Third year. In a 5-year course.
Yes, sir.
Yes. It's a very good idea.
Thank you, sir.
I request the participants to kindly input and would request the judges to kindly fill the score sheet if you have it. Sir?
That is for the presentation. I'm just going to present
The plan.
Yes. So, the team code for the applicant is TC23. I would now like to seek the permission of the bench to kindly start with the scientific part.
Good morning, viewers. I'm 23 and resolution applicant for DSG Private Limited. So the total admitted claims was around 114.91 crores, which were committed, and the team is committing around 94.2 crores, and the overall recovery rate will be around 82.37%. The secured FC, the secured financial creditors recovery rate will be around 76 to 81%, and the OCs and the employees will be paid in full on day one. The CRP cost will be paid on day one, and the employees and the OCs will be paid afterwards. So
Afterwards, in how many days?
it's around more than, it's not in day one, it's around like 1 month to 6 months that will be
That has been captured
in the
plan in the plan.
I don't think so. It's not. So.
That is not there in the plan. Okay, please carry on.
Third slide. DSJ was incorporated 2011. It is EV battery manufacturing since 2018, and it has 3 plants: one in Gurgaon, one in Devenoida, and one in Zirapur, all amounting to 34.4 acres. And the revenue for FY 2024 was 112.4 crores. The profit for that year was 6.3 crores, and the FY 2025 revenue was around 86.5 crores, and the loss on that was 13.9 crores. So the thing was that EBITDA for the FY 2025 was 13.3 crores, but the finance. So basically, what we're saying is that the loss came from all the finance cost that happened in this year, which came around 14.1 crores, that destroyed the profit that could have come. So the main cause of insolvency was that the government withheld 500 crores in EV subsidies in 2022 and not operational failure. And Axis Bank also filed a petition against us in the NCLT, which was in 2025. So mainly what we're trying to say, it's not operational.
What do you mean by against us? Against the city or against you resolution application?
Against the company.
City.
corporate debt. Next slide. The revival strategy is as follows. From day one will be the existing promoter board will be dissolved, and the new we'll get a new board into the company, 3 independent plus 2 DC-23 nominees, and the CEO will be hired within 30 days. He will manage the OEM relationships and the subsidy bid license and the P&L accountability. The CFO will manage the creditor payments, bank license. The CEO will manage the plant managers, ERP. The CEO will manage the OEM contracts and the 34 crores that is in receivables. And the RP, Mr. Devendra Bhatnagar, he will be on a 90-day advisory for knowledge continuity. And how we will actually run the business is as the strategically eliminate the subsidy dependency which was before seen, which led to the failure of the business. And then we will also sign multi-year OEM contracts with that. And then we will reduce the cost to 20% for the raw materials, the domestic sourcing that we have done. And then we will launch 2 new SKUs, the lithium-ion battery, within 12 to 18 months of the rerun of the business. And we will go to Southeast Asia also if possible. Next slide. The phase 1 of the operational plan says that we will restart the Gurugram plant with 40% capacity, and we will inject 25 crores of working capital from that day, and the OCs will be settled in 17.9 crores, and considering the receivables as 19.4 crores that will also be recovered. And the phase 2 says from 6 to 18 months, it says that 80% capacity will start with the Zirakpur plant, and we are expecting a revenue target of 42 crores from that. And we will also, the 2 new SKUs, we are also expecting the revenue from that. And the third phase says that we will be doing 100% utilization of all the 3 plants, and which will come around to a revenue of 95 crores in 2028, and in around 1 year, 155 crores in 2029. Next slide. So the source of funds. Next slide. The team, we are bringing in 30 crores from ourselves, and including the EMD, which is 10 crores, and the co-investor is coming in with 25 crores, and the asset monetization of Greater Noida is around 15 crores, and the trade receivables, we are expecting it to come around 14.4 crores. And the other receivables around 5 crores, the rental income 4.8 crores, total amounting to 94.2 crores, which is 0 subsidiary dependency. And the bank restructuring is Axis Bank, 32 crores were admitted and 26 crores will be offered, which is around 81.25%. And SBI admitted around 20.96 crores, and they will be getting around 16 crores exact. 76.34%. HDFC will get admitted around 23.1 crores, and they will be getting 18 crores, 77.92%, and total secure FCs, they will get 60 crores at 78.89%. And next slide. So the CIP cost will be paid on day 1, which is 1.5 crores before any creditor. Then the secured FCs the Axis Bank, SBI, HDFC, they will be getting 60 crores in total, which is 78.89% from months 1 to 24.
Your upfront payment to secure financial creditors is how much?
I'm not sure.
Last slide.
I think 8, 5 and 9.
Okay, so they will be paid from 1 to 24 months, and then the unsecured FCs, the Voltura, Mobility, Xeon, raw materials, they'll be getting paid 5.7 crores, which is 77.03% from months 12 to 18. And the related party, Zenith Urban Holdings, they'll be getting 2.5 crores, which is 50% from months 24 to 26. The OCs, raw material suppliers and contractors, they will be getting 17.9 crores, which is 100% of what they owe from months 3 to 6. And the workmen and employees, they have an amount of 2.45 crores, and they will also be getting 100% paid. And that is that's the first month priority that we are keeping.
But what is your timeline to your first upfront payment? Because that will be very much material, considering that you say 8 crores, 5 crores and 6 crores respectively will be paid to Axis, SBI and HDFC initially. Then you pay government dues in the workmen and employees on priority in first month, and government dues like GST and PF from month 1 to 3. For us to understand, or for the committee to understand the liquid that you are following the waterfall mechanism, we have to have those specific dates and timelines. Where is that? Is it there in the plan?
It's not.
Then your plan may not be compliant.
That is there on your slide 8.
Slide 8.
Beam reference was also there on slide 6. Yeah, please continue.
So this slide.
Which slide?
Slide 7. The government dues, GST, EF statutory 6.1 crores, 100% paid, and then the grand total comes around 94.65 crores. And that includes the deferred installment funded from operational cash flow that will be hitting in the upcoming months. So around 82.37% recovery. And the timeline is as follows. The day 1 to day 7 will be the CIP cost, employee dues paid, escrow established, and from first month we'll dissolve the board, and C-suit will be appointed, and the upfront banks will get paid 8 crores, SBI will get paid 5 crores, HDFC will get paid 6 crores, so around 19 crores will be paid upfront on the first month, and then from month 1 to 3 will be the government dues will be cleared 6.1 crores, and 25 crores will be injected as the working capital, and Gurgaon, the Gurgaon plant will be at 40% capacity.
What is the treatment to unsecured financial credit, to dissenting financial creditors? When will you pay them in the waterfall, and how much? The creditors who will dissent, supposedly, there is a concept, right? You know it. So that how much you pay them and when do you pay them? And where is it covered in the plan?
That is not covered in the plan. Then from month 3 to 6, the OCs will be settled. The asset will be monetized around 15 crores. The receivables will be recovered 19.4 crores. SKD will be settled. And from month 6 to 18, 80% of Zerapur plant will restart. And then SKU will also launch. The unsecured FCs will be completed by them. And from month 18 to 36, the final plant installments, Zenith, Global will also be settled. All plants will be running at 100% capacity and the EBITDA will be breakeven by FY 2027. And next year.
You have made a reference in slide 9 to a judgment of Lalit Kumar Jain. Promoter guarantee survived NI undertaking. I just want to understand that in case, is it possible legally that I extinguish the promoter guarantee?
Extinguish the promoter guarantee from the company.
Yeah, so guarantees is basically against the loan.
Yes.
So generally the banks insist that guarantees to continue. That if whatever haircut they are taking from the company, they may try and recover whatever possible from the guarantor by initiating personal insolvency. Can it be a possibility that the guarantees be extinguished even in any case?
It can be
Extinguished. But against that, what has to be done?
A tri-party agreement will be there with the resolution applicant, the bank and the old promoters which are given the guarantee.
You will have to read a judgment of NCLAT, Ujas Energy on this particular issue, that how can a bank guarantee be extinguished and in what cases it is. That's because you made a reference to it, that is why I posed this question. You can read through that judgment, that will help you. Okay, continue.
The feasibility, viability and legal compliance. The legal compliance matrix, every provision is met. The CIP cost is first paid. The OCs are paid 100%, which is more than the liquidity entitlement. And the dissenting FCs are paid around 76 to 81%, which is more than mentioned in the section 53. The financial debt restructure is unviable. The PUFT RP applications are continued under the section 53. Water flood is also applied. The section 29 TC 23 is eligible for declaration is also applied. Section 32A full community post approval. Then promoter guarantee. NI will be taken from the previous promoters when they will be dissolved, and performance security is committed.
The judges are hereby requested to please provide their valuable feedback to the applicant.
One advice to you. It is good to make presentation in the classroom. If you are going to any NCNT or any such committee of creditors, it will be very tough for you to answer any of those questions. You need to have resolution plan for the study, and everything should be on test, not on the basis of this presentation. It will create trouble for you.
PPT is no comprehensive,
Yes.
what sir is saying is right. PPT is comprehensive, but you will also have to be hands-on with at least the complete understanding of the plan. You may use this PPT to enhance the experience of the committee or whatever, but your knowledge of the plan has to be unparalleled by anyone. Matlab we are reading, suppose we are reading it for the first time or maybe second. but you have gone through the entire process of making it, presenting it in earlier rounds. So you should be completely thorough with each and every word that is stated and the explanation. You may have your plan also and going through seems very good on the first blush. However, your presentation has to enhance the quality of the plan. That's the only thing.
And start practicing speaking a little louder. Right? That is also very much required for another.
I request the participant to kindly leave the room and would request the judges to kindly fill the score sheet. So, with your permission, shall we call the next participant? The team code for the applicant is TC10.
Good afternoon, resolution professional and the esteemed members of the CEO. We are TC10 and we stand before you today as the resolution applicant consortium for the CIRP process of DSA private limited. Speaker 1 and my co-counsel 2 will be speaking in an alternating manner. Before we proceed, our plan is an answer to all of them. The creditors, Axis Bank, SBI, HDFC, the operational creditors and the employees of DSA who have faced the real uncertainty. We are not here to deliver a presentation. We are here to earn your trust. And we intend to do so not through promises, but through the substance of what we propose. So why should you choose us as the RA for DSA? The answer lies in the way our consortium has been deliberately structured. Our team includes professionals experienced in CIRP proceedings before the NCLT and regulatory investigations such as those before the SFIO, along with an EV technology partner skilled in lithium-ion battery systems and compliance with the FAME standard. So what really went wrong with DSA? DSA was not a failing business in terms of demand or capability. So the question arises, if demand existed, infrastructure existed and relationship existed, why did the company collapse? DSA's business model was significantly linked to incentives under the FAME India scheme, which supported EV manufacturers through subsidies. However, due to alleged non-compliance with the PMP, the Ministry of Heavy Industries withheld nearly Rs 500 crore of subsidies. But DSA was not alone. The FAME to localization controversy of 2022 engulfed Hero Electric, Okinawa Autotech, Empire Vehicles, Revolt Motors, Ben in India and others. But unlike these peers, DSA's distress was a policy-driven liquidity crisis rather than a market failure. Now here is the critical point. When these funds were suddenly withheld, the company faced an immediately liquidity shock that triggered a chain reaction. The inability to service debt, strain on supplier payments, operational slowdown, and the eventual financial distress.
Sir, this is not a story of a failed product. This is a story of a regulatory shock. And regulatory shocks, unlike product failures, are correctable where we come into the picture. The SFIO investigation is a significant legal shadow over DSA. However, the IBC provides a well-established statutory remedy that is Section 32A. This provision was upheld and affirmed by the Honorable Supreme Court of India in Manish Kumar 2021 case, wherein the court confirmed that the clean slate is not merely a procedural benefit, it is a fundamental feature of the IBC's resolution architecture. Our commitment is absolute. Neither Mr. Mandeep Singh nor Mr. Vikadana will hold any position, be it direct or indirect, in the revived DSA. Section 32A protection is not just a legal benefit, it is a government imperative. Now, second is the FAME subsidy dispute. The consortium's legal strategy regarding the 500 crore FAME subsidy dispute is treated as a contingency upside rather than a financial baseline. Now, this strategy follows three parallel tracks. Track 1 involves aggressive litigation with senior counsel and third-party funding. Second one focuses on regulatory correction through a localization audit. Track 3 seeks a negotiated settlement for partial disbursement based on 2023 industry precedent. So this is mentioned in page number 12 of the resolution plan. Any successful recovery will be shared with 30% distributed to creditors as a special dividend and 70% allocated to capital upgrades. Moreover, the pending writ petition before the Honorable High Court challenging the Ministry of Heavy Industries' decision to withhold 500 crores in FAME subsidies is a genuine legal asset. But we want to be absolutely clear with this committee. Our plan is not dependent on these subsidies. The third one is the proof-pay transactions. Under section 2.2, so page number 12 to 13 of the resolution plan, the RA addresses 17.5 crores in potential proof-pay transactions identified by the RP under section 43, 45, 49 and 66 of the IBC. Now within 30 days of NCLT approval, Big 4 forensic auditors will be appointed to provide a comprehensive report within 90 days, followed by aggressive legal action via a dedicated LMU litigation management unit. Now in alignment with judicial precedents like Tata Steel versus Venus Recruiters, the plan explicitly grants the successful RA the right to prosecute these actions. Every rupee recovered will flow directly to creditors through a monthly audited ring-fenced escrow account distributed as enhanced dividends above the base offer. The third mentioned in page 16 is the proposed management structure. So the clean slate doctrine as affirmed in Manish Kumar case requires not just legal compliance but a total governance overhaul. Following the approval of the RP, DSJ will move from a promoter-driven governance model to a professional management structure. The revised DSJ will be led by a professional management team comprising a chief executive officer focusing on OEM partnerships and market presence, a chief financial officer responsible for creditor reporting, a chief operating officer for day-to-day plant management, and a chief technical officer to lead the R&D roadmap including solid-state battery product. During the initial 12 to 18 month implementation plan, a monitoring committee will provide structured oversight, which includes a representation of our consortium, a nominee from the secured financial creditors, that is Axis Bank, SBI and HDFC, and the former RP, serving in an advisory capacity. Sir, a CRO, Chief Restructuring Officer, will be appointed for 24 months, a role used effectively in the Bhushan Steel resolution, where he will supervise the implementation of the turnaround strategy, ensuring that operational and financial restructuring are executed efficiently.
Now, before we move to the financial numbers, the COC must understand what we are actually doing with the capital we are committing. An RP that pays creditors well but leaves the company operationally hollow is not a resolution. The Supreme Court in Swiss Ribbons v. Union of India 2019 held the validity of IBC itself and held that the primary objective of the court is resolution and not liquidation. As the Honorable COC may kindly observe in the RP, our three-phase plan is entirely built around this concept. So the first phase is the month 0 to 6. These first 6 months focus on arresting financial erosion and restoring regulatory standing through a disciplined approach. Initially, a FAME 3 PMP specialist will be appointed to conduct a localization audit. Subsequently, Rs 15 crore in fresh working capital will be infused to clear the dues and restart the assembly lines, targeting a swift operational revival in line with the SLR Mittal SR Steel precedent. Then applications for FAME 3 and PLI eligibility will be pursued, and simultaneously testing as a service model will be launched at a 34-acre campus to generate immediate zero capex cash flow by offering facilities to EV startups and OEMs. Then moving to phase 2, that is year 1 to 3. Now with the stabilization secured, our phase 2 will focus on scaling operations and reducing the concentration risk. Initially, DSJ will expand into battery modules for light vehicles, targeting a 40% revenue mix with minimal Rs 5 crore retooling, enabling swift market entry and OEM partnerships. Then a compliant battery recycling facility will be established, which will process 500 tons, recover up to 95% of key minerals, and which will also support the India's critical minerals mission. Thereafter, Rs 20 crores will be invested in in-house BMS manufacturing, reducing import dependence upon below 30% and strengthening the supply chains and securing PLI eligibility.
Now let's move on to the financial proposal. As the Honorable COC may kindly see in the RP, now we will walk you through the total resolution consideration, the sources of funds, the distribution among creditors and the rationale behind each number. So the total resolution consideration proposed under this plan is 106.83 crores. It is mentioned in page 27, sir. But the question is, how did we arrive at this figure?
Against 114 crores.
Sorry?
Yes.
106.83 crores.
We are
Against 114 crores.
Yes.
Of the admitted liability.
Yes.
Right. We are offering 106.8 against.
Yeah, please.
Indeed, sir. The going concern enterprise value of DSJ is estimated between 180 to 220 crores, which reflects the value of DSJ as a running enterprise, not merely the liquidation value of its assets. So an obvious question arises, why is the offer 106 and not the entire 140? Now the answer is simple, sir. If every rupee were immediately distributed to creditors, the revived DSJ would have no capital to restart operation, no funds, no utilities, or restarting production lines. The company would technically exit CIRP but practically collapse. This concern was recognized by the Honorable Supreme Court in COC of SRC versus Satish Kumar Gupta President, where it held that resolution plans must be evaluated not merely on creditor recovery but on the long-term viability of the enterprise.
Now, if the Honorable COC may kindly observe and turn to section 5.1 of the resolution plan. Now, this section explains exactly where those rupees 106.83 crores will come from. Firstly, the promoter and acquirer equity contribution will be 45 crores. Now, this will be direct equity infusion by the consortium promoters. Then moving to the strategic debt financing, which will be 40 crores, and thirdly, the operating cash flows, which will be 15 crores. Fourthly, we already have a rental income of 2.40 crores, and fifth is the subsidy contingency reserve 4.43 crores, which is purely contingent and it is not included in the base financial projection.
So the total consideration of 106.83 crores, it is structured in two tranches, balancing immediate recovery with long-term viability. The first one is the upfront payment. Approximately 70 crores will be paid within 60 days of NCLT approval. Now this tranche fully covers 100% of CIRP costs, 100% of workmen and employee dues, and 100% of statutory government dues such as GST, while also paying around 60 to 70% recovery to secure financial and operational creditors. So the second one is
dissenting financial creditors.
Sorry.
If there are dissenting financial creditors, how do you intend to pay them?
So we are already paying 100% to the secured financial creditors and to the employees, and also to the operational creditors we are paying 95% of the admitted creditors.
So the second one is the deferred payments. The remaining 36.83 crores will be paid over months 3 to 36 through structured installments funded by our operating cash flow and secured through a payment escrow account, ensuring priority allocation of revenues. For this portion, financial creditors will receive secured non-convertible debentures, tradable instruments that offer liquidity flexibility, allowing creditors to exit earlier if they desire. This structure ensures both immediate certainty and sustainable
As per
financial
your
stability.
plan, unsecured financial creditors are paid in two tranches. One within 60 days, you will come to page 30 at the top.
Yes. Thank you, sir.
Yes, so within 60 days we are paying 50% upfront, and then we have deferred payments,
We have
which will be
divided
50%.
two tranches.
But over 18 months, but is it possible that you can defer the payment to unsecured financial creditors?
But so we will prioritize it for the secured financial creditors, and as we have the money, and we will then give it back to the unsecured one as well. We have to prioritize it to the financial creditors first.
Okay.
Like it's not possible to give everyone 100% in the upfront payment only. So we have divided the tranches, and first is the upfront payments, and secondly it's the deferred payments, wherein the operational and unsecured financial creditors will be paid 50%.
But you have not treated anywhere what will happen to the dissenting financial creditors. You say that they are workmen, but these are also unsecured financial creditors may also dissent. If they dissent, then what will be the treatment to them? How will you basically incorporate payment to them in this resolution?
So we are already paying 50% upfront, and which will
Get it? That's not my question. My question is, if they dissent,
right.
the entire distribution hinges upon that everyone has agreed.
Right.
if there is a dissenting financial creditor, law says that they have to trade in parallel. How will you adjust them if any of the unsecured financial creditors dissent?
So we are already giving more than what others are offering. So we will be giving them a comparison. Like if the liquidation happens, they might not receive 80% even, and we are giving 50% upfront, and even we have like if they dissent, we could.
But how would you know that others are giving lesser than what you are giving?
So because this is
Others plan, you don't have the others plan.
right.
This is
Sir,
the
but
near to maximum amount that
Yeah.
we can offer. As
like it's not possible to give everyone 100%, and we are already giving the maximum
The
value
maximum.
that they can have. Like 80% is a big amount even for unsecured financial credits.
Sir,
I am not doubting your analogy to that you are paying 80% to them. That's not the question. The question is that even if after that someone says, like, I don't want this, I want my 100%, and they dissent, they vote against the plan.
So I think our skills of persuasion would have to come into the picture in that point for the dissenting creditors.
Okay. Okay. Next.
Now we are going to walk you through the distribution to each creditor category along with the legal basis for the proposed treatment. First is the mandatory dues, which will be 100%. That is for the CIRP process on day 1, we are given 100%. To the workmen 2.45 CR, and to the statutory payments within 45, 6.10 crore. Then is the secured creditors, we are paying them 95%, which is 72.25 CR total, which will be 70% upfront and 30% will be 24 months through NCD. Then we have operational and unsecured creditors, to whom we are giving 80 to 90%, wherein trade creditors will be having 90% and the unsecured, that is Voltura and Xeon, will be having 80%. Then the related parties will be having 50%, that is the Zenith Urban Holdings, which will accept a 50% haircut with the deferred payment.
Members of the committee, as you may observe in table 8.1 of the RP, the true test of this proposal is simple. How does it compare with liquidation? Under section 33 of IBC, sir, liquidation would mean selling the assets of DSJ piece by piece through the NCLT process. Specialized EV manufacturing assets rarely fetch fair value in distress auctions. The estimated liquidation value, that is 50 to 55 crores. Now we can compare with this plan. The secured financial creditors, that is Axis Bank, SBI and HDFC. In liquidation, they would get 50 to 60%, and under our plan, they would get 95%. Operational creditors, in liquidation, they would get 20 to 30% versus 90% in our. The unsecured financial creditors near to zero in liquidation versus 80% recovery under this plan. In total, liquidation leaves over 50 crores less for creditors. And history supports this part. Companies like SR Steel, Bhushan Steel and Electro Steel Steels were revived through resolution, not liquidation. So the decision before this committee is clear: distress sale or value revival. While no resolution plan is entirely risk-free, sir, our approach replaces uncertainty with precision through 6 enforceable safeguards. We leverage section 32A of the IBC to ensure total immunity from the ongoing SFI proceedings, appointing a Big Four auditor within 30 days to guarantee a clean slate, while completely excluding foreign promoters. Financial stability is decoupled from the 500 crore FAME subsidy litigation, which we treat only as a contingent upside, while future regulatory risk is eliminated by slashing import dependency from 60% to below 10% through partnerships with Reliance and Ola Electric. Revenue is secured via letters of intent from anchor OEMs and contrast manufacturing with Excite, supported by immediate cash flows from our testing as a service model. Finally, creditor interests are protected through a supervised escrow account and tradable NCDs with speculative R&D into solid-state technology, strictly deferred until EBITDA break-even is achieved. Now we formally place on record our compliance declarations under the IBC 2016, confirming that all consortium members are eligible under section 29A with no ties to prior management or NP accounts. In strict adherence to the section 32, we guarantee that CIRP cost of Rs 1.50 crores will be paid in full on day 1 with absolute priority, and our operational creditors will receive a 90% recovery, which is far exceeding liquidation benchmark. Our equity and debt commitments are unconditional, based on conservative financial assumptions, and are supported by full material disclosure. We recognize the committee's authority under section 34 and submit these binding declarations as an integral part of our plan to ensure a transparent, legally certain and value maximizing revival for DSJ private limited. Honorable COC, we have walked you through every aspect of this resolution plan, its legal foundation under the IBC 2016, its operational roadmap, financial structure and the risk safeguards. But let us end with the core question before the committee. Our plan offers INR 106.83 crores against a liquidation value of roughly 50 to 55 crores. It delivers 95% recovery to secure financial creditors, 90% to operational creditors, and full payment to workmen, employees, and government dues, supported by an escrow-backed and NCT secure structure. Liquidation, by contrast, halves the value, dismantles assets worth rupees 200 crores, and permanently erases nearly 300 jobs. So the real question before the committee is simple: revival with value or liquidation with gossip. We urge this committee to exercise its commercial wisdom and appeal to that. Thank you.
The judges are hereby requested to please provide their valuable feedback to the participants.
I think overall a very good presentation. The few gaps that I found which are actually ours is with respect to your treatment is not there, which will actually be an impediment. I think your plan also seems to be a little well researched.
Like, so we have added multiple things, like we have added a testing as a service model, which is a task, and we also have a battery leasing model where we will be leasing batteries so that there is a recurring revenue model.
Also, so the CAFE norms, the corporate average fuel efficiency norms, they also come into the picture in our matter of ESG. The companies have to shift into the EV industry, and they would require the EV batteries. So DSJ would be revived, should be revived.
And we will be doing contractual with the OEMs, right? And we will be like utilizing the 34-acre land that DSJ already has. So we will be converting it to an EV hub, and like it will be a full ecosystem for startups and other.
Also, we are getting 20 lakhs rent per month
From XYZ private limited.
So that can also be used.
Total duration would be around 3 years.
It would take time for it to rise.
For the
Yes, sir,
payment,
but-
I think that is asking for the payment.
Yes, sir, but most of it has been paid upfront, like the secure
It was the
creditors.
complete
Yeah,
resolution
they will
plan.
be.
And you have kept related party settlement at 24 to 36 months.
50%.
The
That is
2.5 crores. The timeline would be 24 to 36.
Yes. But it will be profitable company.
There are several precedents as well. SRC and Swiss differences there and Mars there. Tata Steel is also there.
Thank you.
Thank you.
I request the participants to kindly leave the room and would request the judges to kindly fill the score sheet if you have it. Thank you, committee, for your valuable time. I would now request Ananya Sharma to get vote of thanks.
Respected judges, faculty members, dear participants, and our wonderful audience, on behalf of everyone, I extend my sincere gratitude to our esteemed judges for their valuable time, insightful evaluation and guidance. I would like to thank our faculty members, Ms. Manika Gandhi ma'am and Ms. Simran ma'am, and our convener, Vani, and organizing team for the constant support and effort in making this event a success. A big congratulations to all the participants for their enthusiastic participation and impressive performance. Lastly, a heartfelt thank you to our audience for your presence, encouragement and energy throughout the event. Thank you all for making this event truly memorable.
Should we go there?
straight away?
Yes, sir. Yes.
Things are not here. Some teams are not here.
So now we will begin with the briefing session, or a short briefing session for you all, and then the teams will arrive. So I think we have a bit of सुनना चाहिए.
We have read the problem on it. There's no problem. If you want to explain me, it's fine.
The brief about the rule book. We have three things to brief about: the problem, the rule book, and the social.
So I think rule book and score sheet को ही concentrate करें. Sir, with your permission.
Okay, so I started the rule book for the finals. The rules as laid down in the 6th Justice J.S. VERMA Memorial ADR and Client Counseling Competition 2026 Arbitration Rulebook with the final round are as follows. The total time for this arbitration session will be 80 minutes, inclusive of rebuttals, sub-rebuttal and post-consultation session. Each team shall get 30 minutes and each speaker shall get a maximum time of 15 minutes. In addition, each team shall get a time of 5 minutes for rebuttals and sub-rebuttals. The time split among the speaker must be decided among themselves and intimate the same to the room captains in the beginning of the rounds. The organizing committee supervising the session shall be the official timekeeper of the session. Teams have the responsibility to adhere to the time limit. Exceeding the time limit will lead to negative marking. Now Yashi will continue with the score sheet. The score sheet of Main 6 Justice J.S. VERMA Memorial EDRCC Competition 2026 Arbitration Competition. The scoring criteria are as follows. The blue theme is of requesting party, which is AB10, and the red theme, which is of responding party, AB20. We have 5 criteria of judging: application of facts, reasoning, use of authorities and precedents, understanding law and procedure, and presentation. The scoring scale includes outstanding 18 to 20 range, excellent 14 to 17 range, average 9 to 13 range, poor 5 to 8, and very poor goes under 1 to 4. Thank you for the last part of the scoring scale includes the score out of 20 numbers, which is of outstanding 18 to 20, excellent 14 to 17, average 9 to 13, poor 5 to 8, very poor is 1 to 4.
Same one.
Final rounds of the arbitration competition, organized by Maharaja Abhisain Institute of Management Studies, Delhi. We are honored to have our expert assessors in the room with us. We are highly obliged to welcome you for adjudicating this round. It is hereby requested to the assessors to kindly fill the score sheets after the arbitration session ends. Before starting with the final rounds, we would like to brief the assessors and the teams about the functioning of this room. I, Aditya, will be serving you as a room captain 1 and will be assisting with maintaining the decorum of the room, and Soumya will be serving you as a room captain 2 and will be assisting with time moderation. Before starting with the round, we would like to brief the time bifurcation. As written in the rule book, the total time for the arbitration session will be 80 minutes, and it will be included of the time of rebuttal, sub-rebuttal and post-analysis session. Then the team code for the requesting party is AB10 and the team code for the responding party is AB25. The assessors can seek increase their time beyond the time written in the rule book. Now I'd like to seek the permission of the assessors to start with the round. I now like to seek the permission to start with the round. Sorry sir, one mistake. The team code for the requesting party is AB20 and the team code for the responding party is AB10 and AB20. I now like to request the team to start with the round.
This is AB10, right?
I would like to start with a countdown of 3, 2 and 1. Greetings to the members of the tribunal. I, Shreya Raj, along with my co-counsel Ms. Ishika Agarwal, appear here on behalf of the claimant in the matter of Organised Construction Company versus Department of Public Works Logistics. I will be addressing issue 1, 2, 4, 7 and 8, while rest of the issues will be dealt by my co-counsel within the time frame of 15 minutes each. My following issues are as issue 1 and 2 regarding the maintainability and timelines of the claim, followed by issue 4 on the illegality of the termination, and concluding with issue 7 and 8 regarding our concern or entitlement to overheads the interest. Beginning with the fact of the case, on 10th April 2012, the DPWL awarded a 750 crore residential construction contract to Organised Construction Company with a 30-month completion schedule. The project continued for 48 long months, during which various delays and extensions occurred relating to site access and issuance of the structure design. On 15th October 2016, with approximately 75% work done, the DPWL terminated the contract and subsequently engaged a risk and cost contractor, Rishikesh Infra Company, for the remaining work. Herein, the claimant seeks 142 crores for wrongful terminations and overheads, while the respondent filed a counter claim of rupees 131 crore for risk and cost expenses. Therefore, issue before this tribunal are to determine the parties responsible for the delay and legality of terminations and resulting financial losses. With that brief background, members of the tribunal, now I would like to begin with the issues. Much obliged. The very first issue before this tribunal is whether the statement of claim is liable to be rejected as the director of Agni Super Infra Company, which is one partner company of the claimant partnership, did not have the authority of the other partners to file and sign the same. Members of the tribunal, it is the respectful submission of the claimant that the statement of claim is valid, maintainable and legally binding upon this tribunal, and the respondent objection is completely misplaced. Moving forward with the submissions, firstly, the signatory possessed implied authority under the doctrine of mutual agency. Members of the tribunal, the claimant Organised Construction Company Limited is a partnership firm comprising two constituent corporate entities, namely Agni Super Infra Company and Best Construction Company. Under Section 19 of Indian Partnership Act 1932, every partner is considered an agent of the firm for the purpose of the business of that firm.
I have a question for you here. Sorry to interrupt. Could I get your name again, please?
Shreya.
Shreya, when you say company and then you say partners.
No, it is the two companies form the partners there for the purpose.
That's exactly what I'm saying. So when you say companies, either it can be a company or it can be a partnership firm.
This is a partnership firm.
It's a partnership.
Every partner is considered an agent of the firm for the purpose of the business of that firm. The principle establishes the doctrine of mutual agency, which lies at the very heart of the partnership law. Which means, member of the tribunal, that each party has the authority to bind the firm through the act done in the ordinary course of business. The Supreme Court, in the case of Purushottam and Company versus Manilal and Sons, undertaken affirmed this principle, recognized that act undertaken by one partner for the benefit of the firm binds the partnership as whole. I now request members of the tribunal to kindly refer page 1 of arbitration problem, the name of the party. The statement of claim itself clearly states that the proceeding were initiated as Agni-based construction company through its partner Agni Super Infra Company. The phrase here, through its partner, itself demonstrates that the partner was acting in a representative capacity on behalf of the firm and merely not in an individual capacity. Therefore, the act of signing and filing the statement of claim cannot be used as an unauthorized act, but rather as an exercise of implied authority that flows naturally from the doctrine of mutual agency. This leads me to my second submission, member of the tribunal. That is, even if the members were to assume arguendo that the signatory lacked express prior authorization, the doctrine of ratification would nevertheless validate this act. Under the established principle of agency law, an act performed without prior authority can subsequently be ratified by the principal, thereby giving it a full legal effect after that. In the present case, the second partner, West Construction Company, has never raised any objection to the filing of the statement of claim. Such conduct clearly amounts to implied ratification of the act performed by the signatory. With no further questions, member of the tribunal, I now seek.
Was there any express authority given at any point of time?
No, there was no any express. There was no
any power of attorney, any board resolution, anything.
No, but the name of the statement of claims was filed as the Agni-based construction company through its partner. The word through here demonstrates that they are in a representing capacity.
See, what are the consequences of a registered partnership and the private limited partnership? What are the consequences?
Can you please pardon, sir? I'm not getting.
If you are talking about the Partnership Act, then registration of a partnership is also formed by the Partnership Act, and the liability and duties are different. No. Okay. Okay, continue.
I have a question. This implied authority includes the power to invoke the arbitration clause also? Have you gone through the entire act?
I have gone through the entire act.
There is one particular section which says that this implied authority does not include the power to invoke the arbitration clause.
Article 19 clause 2 subclause A, I guess it is.
Read that so that others can also.
It is the claimant's respectful submission that the statement of claim.
You should read this section.
Sir is asking you to read that particular section for our benefit.
You know to direct? Counsel will not direct?
Can somebody give her the act, please? Excuse me. Can you please pass on the act? You have the arbitration act? Yes.
Arbitration partnership act.
Okay, partnership. Sir, you are asking for partnership?
Yes, yes.
Oh, partnership.
Don't do partnership. This is the very first issue.
When the issue is regarding partnership, you should have a partnership act at least should rely upon some sections or something on that. Anyhow, continue.
It is the claimant's respectful submission that the claims are not barred and fell within the prescribed limitation
No,
period.
this is issue 2.
Issue 2. Whether the statement of claim are time barred or not. So my submission on this issue are as follows. Firstly, the limitation was arrested under section 21 of Arbitration and Conciliation Act. Members of the tribunal, section 21 of Arbitration and Conciliation Act 1996 contains a deeming provision which determines that the commencement of arbitral proceedings for the purpose of limitation. Under this provision, the arbitral proceeding commences on the date when the request for the arbitration is received to the respondent. The Supreme
And when did the respondent in your case receive this?
Just after the 1 month of termination.
That's when you gave.
We gave the notice on 15th November 2016.
So what is the limitation period for filing an application under section 11 of the Arbitration Conciliation Act?
It is not
After
mentioned.
invoking the arbitration clause under section 21.
It is not mentioned in Arbitration and Conciliation Act.
which-
It is read with Limitation Act. That is Article 137 of Limitation Act states the 3-year period. Gives the three
So
year
did you
period.
file your application within 3 years?
No, we invoked the arbitration just after one month. So Article 21 of Arbitration and Conciliation Act states that the dual time period locks at that period.
What is this dual time period?
It is
Nothing so mentioned in that dual time period.
It is stated in the limitation.
How are your claims saved from this rigor of Limitation Act, Article 137 particularly of the Limitation Act? It says you have to move an application within 3 years. So you have filed this application under section 11 after 4 years.
But we have initiated the invocation after just 1 month.
That is exactly what our question is. Once you invoke the arbitration clause, thereafter does a limitation stop for you?
So the Supreme Court in the case of State of Goa versus Praveen Enterprises reiterated that section 21 notice effectively stopped the limitation clause for the underlying claims.
Does it provide you immunity to file the application under section 11 after 4 years? You have taken 4 years, 10 days.
We have taken 4 years, but there was continuous hindrance caused by the.
You are talking about your claim. We are not talking about your claim. We are really talking about the time limitation.
And how were there continuous hindrance once the contract has been terminated? How can you say that after 4 years, even after the 4 years, the hindrance were there?
They encashed their bank guaranteed also.
So?
It was also
Is
barred
this the
by,
hindrance?
it was also barred by limitation.
So can the time be extended like that? What are the 137 says?
137 says that 3-year period is being provided for taking.
So what about the rest of the period, 1 year and some few days? What is the explanation for that? Can it be extended? Then you admit it is a time bar.
We have invoked the arbitration. Just 1 month.
See, don't you have this, argument that they did not raise this objection while the application under section 11 was filed before the High Court of Delhi, so they have waived this? You don't have this argument in support of?
Sir is trying to help you.
So can't you say that this issue cannot be raised before the tribunal now? Can there be a doctrine of waiver applicable in these kinds of cases? You haven't studied about all these aspects? No. All right.
Now I seek permission to the members of the tribunal to address issue 4, which is whether the condition of nil financial effect in the extension letter is valid or vitiated by the coercion. It is the humble submission of the claimant that the condition of nil financial effect attached to the extension of time is legally void and unenforceable, as the consent of the claimant was obtained under economic duress and coercion. The claimant had already invested substantial resources into the project and had mobilized manpower and machinery at the site. At that stage, the termination of the contract would have resulted in severe financial losses. Therefore, the claimant has left with no reasonable alternative but to sign the extension letter. The Honorable Supreme Court in the case of Central Inland Water Transport versus Rozonar Ganguly held that one-sided contractual clauses imposed by a stronger party to the weaker party are liable to be struck down. And in the present,
how is this case applicable here? Because this is not a case where the contract is between or receiving party, which is having no say in the contract, like citizen, normal citizen. It's a business contract. So in business contracts, such kind of doctrines do not apply. It's a standard form contract. We do agree with that. But doctrine of these kinds of system form contract do not apply where the contract is between business entity and the government office. You have not gone through this aspect?
Doctrine as in?
This is a contract of addition. This is called contract of addition. In this very first case, Bojanath Ganguly, first time this concept was incorporated in India by the Supreme Court, borrowed from Chitti's law of contract and other British judgments. And in this case, Bojanath Ganguly was an employee of this corporation. He did not have any say. He did not have any bargaining power. But while you enter into any kind of contract with the government or with any other business entity, while you yourself doing this case, entering into this contract for the purpose of business, you do not apply these kinds of doctrines, receiving and procurement. You don't know. You did not read the case of Classic Motors Limited versus Maruti Udyog Limited, decided by Delhi High Court. The classic case on this aspect. We should have found out some ways to get out from the rigors of this case, where the principles were laid down.
My second submissions on this issue are there is no genuine consensus at ADM between the parties. It is a settled principle of contract law that the free consent is the foundation of a valid contract. Under Section 13 and Section 14 of the Indian Contract Act 1872, an agreement becomes a contract only when the parties agree upon the same thing in the same sense, and when only it is considered that the consent is free. However, in the present case, the claimant consistently protested the hindrance and the delays caused during the execution of the project. The signing of the extension letter was therefore not a voluntary settlement, but a survival measure adopted by the claimant to avoid the immediate termination of the contract.
So, where this term coercion is defined, you are saying that there was coercion upon you.
The coercion term is defined in Section 15 of the Indian Contract.
And what are the consequences of if coercion is there? Coercion, if applied by one party, what are the consequences of that? Is there any act which defines the consequences of coercion? This Contract Act itself, Section 19, you should read it. Read Section 19. You don't have Contract Act also, alright. And did you lodge any kind of protest when coercion was applied? Did you lodge any kind of fire also, or any letter?
While filing our extension letter, we had...
You never lodged any complaint. You accepted this nil financial effect. So how do you get out of this at the time of argument?
Because lots of money was on stake, and if we had moved towards the cases and all, then the project was delayed by a day and hours.
So this is the benefit you reaped. See, this was your consideration. You wanted to continue with this project. You did not have any serious objection against it. Anyway.
Members of the tribunal, I now seek permission to address issue 7, namely whether the respondent was liable to extend the project timeline in the light that the positive recommendation made by its own officer. In the statement of it is the claimant's respectful submission that the respondent was legally obligated to grant a third extension of time, as the internal noting of its board of officers clearly established that the delay in the project was caused by departmental hindrance attributable to the respondent itself.
I have a question here. Is a superior officer bound by the will of its subordinate people?
No, they are not bound, but in the case of SETI Auto Service Station versus Delhi Departmental Authority, where the Supreme Court held that such notings constitute relevant evidence reflecting the decision-making process and factual basis of administration actions.
See, if it is so.
And in the present case, the respondent's own technical experts acknowledged the project faced obstacles caused by the respondent's inability to remove side hindrance. Consequently, the respondent cannot now shift the blame onto the claimant. And it is also the settled principle that a party cannot benefit from its own wrong, particularly when the delay is attributable to its own cause of action or omission.
The issue is, if a junior officer recommends something So the seniors are obligated to accept that, and what is the role of these seniors? Just like a rubber stamp?
No, they are not. They are not bound to follow them, but it is an internal noting, and it carries a wholesome aspect as to establish a valid cause of action that rests upon the existence of a legal right and a corresponding breach. So, in
do you get the right in case there is an internal noting in the government files? That just give rise to any right?
Here in the present case,
or you get the right only once it is communicated to you.
Yes, so
Suppose a government authority terminates the services of a person, like employee, but this letter is not issued to the employee. Will he be bound?
They are not bound, but it carries a kind of it carries a relevant evidence. Okay, reflecting that the decision.
What is the meaning of evidence?
Evidence as in.
No, here this term is defined. This section of which act?
I now proceed to address issue 8. That is which party is attributable to the delay in the execution of the project. It is most humbly submitted before the arbitral tribunal. That is the respondent. That is the respondent. Department of Public Work Logistics is solely responsible for the delay in the execution of the project. I shall respectfully submit each submissions in turn. Firstly, the respondent failed to provide a hinder-free site and timely approvals at the outset. It is submitted that under construction contract, the primary obligation of the employer is to provide the contractor with a hinder-free site along with necessary technical approvals and drawings. Under Section 52 of Indian Contract Act 1872, where reciprocal promises are to be performed in the particular order, the demanding performance for the other order. In the Honorable Supreme Court in the case of...
The issue is, if the reciprocal promise is not performed by one of the parties, then what are the consequences of that? Are you not entitled to terminate the contract on your own by stating that you are not providing the hindrance-free site to me, so I am not obligated to perform this contract? Why don't you exercise that right?
I again quote that our lots of money is on stake. We as a professional construction company, it is our image outside the.
Yes.
So in the Honorable Supreme Court in the case of Wilson Solutions Limited versus Oil and Natural Gases Corporation held that the employer cannot impose liability for delay upon the contractor where the employer itself has prevented the contractor from performing its obligations. And in the present case, the respondent's failure to provide a fully operational and obstruction-free work environment significantly hindered the progress of the construction. By failing to perform its obligation first, the respondent efficiently put the project timelines at large and cannot now attribute the delays to the claimant. Secondly, it is further submitted that the timely payment for work executed is the lifeblood of any construction project. I request members of the tribunal to kindly refer Statement of Claims, page 4 of arbitration problem. There the respondent repeatedly failed to release the payment within the stipulated period, within the stipulated contractual time frame. The failure directly violated the payment obligations of the other party.
So what kinds of rights do arise in your favor in case payment is not made on time? Do you get the right to terminate the contract? Do you get the right to seek interest over the delayed payments? Do you get the right to seek extension of time for the delayed payment? These three things are totally different. So you address few of them. How do you get the right to get time extended, just because payment was not made on time? You are working on the site. How did it affect the progress of the work?
It is affect the not this is the only cause that is being done by the respondent. There are also so many causes like the other construction work is also.
Should you not be confined to this specific issue? why are you addressing other issues, bringing them? You just address this issue specifically, that how did this project get delayed just because the payment was delayed by the employer.
The payment was delayed by the employer. That is created our money flow. Like we have also to pay our workers to pay on the.
Apart from the payment, was there any other obstruction also?
There was not any other obstruction.
Payment
also. Payment is the.
Payment is a primary factor for you.
Yes.
But they gave you everything. Otherwise, whatever was required in the contract.
They are not providing us the.
You have not stated so anywhere in the claim or somewhere.
We have studied previously. Sir has
Not
to
in the
stick on this issue.
It just started with reciprocal promises. So that's what exactly sir is asking. So you said there was only one difficulty, but you spoke about reciprocal promises. So what was the other things?
Other things like they are not providing. The other construction project was also going on that vicinity. That is creating hindrance to our project.
What was that?
It is not specifically mentioned, but it is mentioned that the other construction work is also going on.
Too many things mentioned in the program. I guess you have not gone through.
It
was not provided to you on time, right? Okay. And could it not be
while we are filing our extension letters, we had filed 3 extension letters. By each extension letters we had.
So why didn't you mention all these things when sir was asking you?
Exactly.
These are all reasons for seeking extension. All these 3 letters you
So
have mentioned.
these are the firstly it was handed over late. That we filed in our first extension.
What was handed late?
The construction project, the site was handed over late. In our second extension, we filed that they had late approval of sample of projects. They approved us late. And in our third
samples of project,
samples of materials. Samples of material. And in the third extension, we filed that they are causing hindrance.
Hindrance of what kind?
Hindrance of
extra work was given to you, deviations were there. You have not gone through the program.
Contractors were also working there.
You have taken your time.
You're not keeping your time limit? There's still time left?
No, time is over.
You didn't mention it? You didn't show the plate?
So I did.
You did?
Yeah.
You did? You should have come in so that we can also see.
And this one
second speaker. See, the issue is about the, punctuality and time, adherence to the time limit.
So now I would like to yield the floor to my co-counsel, who will be dealing with the rest of the issues.
Greetings of the day. My name is Ishita Agarwal and I represent claimant side in the present matter. I'll be representing the following issues, namely issue 3, 5, 6, 9 and 10. My submissions will proceed in the following manner. First, I establish that the delay was caused by the respondent's own failures, including site hindrances and administrative lapses.
Second, aren't you supposed to be concentrating on issue number 3?
Yes, ma'am, I'm supposed to do that just after stating how I'm going to represent my issues to the members. And secondly, I'll demonstrate that claimant cannot be penalized for delays it neither caused or could not control and is therefore entitled for extensions and consequential reliefs. With the permission of the tribunal, I would now like to proceed with the following issue. I now proceed with issue 3. Issue 3 concerns whether the counterclaims of the respondent are barred by limitation. It is respectfully submitted that the counterclaims raised by the respondent are time barred and therefore not maintained. My submission.
When does the time limitation for counterclaim begin?
15 October 2016 was.
What is the time limitation given for counterclaim? Is it the same as a suit?
No, it's not same as a suit, but the time limit for the counterclaims were about, I guess, 3 years.
I guess. You are guessing?
No, I'm sorry.
No, Pangal? See, you have not gone through the Limitation Act. Limitation for filing claims for the central government and the state government entities, ministries, etc. is 30 years. Meanwhile, you examine and then apprise us if it is wrong. With the research.
Should I continue? My submissions on the following issue flows in three parts. The cause of action for the counterclaims arose much earlier and had already expired. A counterclaim is an independent claim and does not relate back to the date of the main claim. The respondent failed to act within the limitation period. First, the cause of action had already expired. Members of the tribunal. The respondent's alleged losses arose at the time of termination of the contract and appointment of a new contractor. Therefore, the limitation period began running from the date of termination, which was 15 October 2016.
So same applies to your claims also. If their counter claims are barred by time, so why are not your claims time barred?
The most relevant question.
I would like to continue further. The limitation period began from the date of termination, which was 15 October 2016, not from the filing of the statement of claims. Secondly, counterclaims are independent proceedings. The Supreme Court in the state of Goa and Pravi Enterprises held that counterclaims and arbitration are separate, and independent claims independent claims must independently satisfy limitation requirements. Therefore, a counterclaim cannot automatically relate back to the date of filing of the original claim. Thirdly, the respondent slept over its rights. The respondent remained inactive and did not assert its claims within 3 years from termination, thereby rendering the counterclaims barred under the Limitation Act 1960.
Is it necessary for the respondent to invoke the arbitration clause on its own to file its counterclaim, or can it file the counterclaims in reply to the claims? What is the law as on today in this regard?
So, if we are talking about law here, then the invocation of the arbitration proceedings should have been invoked before the counterclaims. And
you mean to say that the counterclaimant should also invoke the arbitration clause separately?
Yes.
You have not gone to the latest law by Delhi High Court recent judgment, which says that there is no need to invoke the arbitration clause for filing the counterclaims. You can file them in reply to the claims along with your statement of defense.
The question arises, what are the timing for the filing of the counterclaim? How you are going to compute it?
so the filing of
You should have limitation at least when you are addressing all these issues. Issue number 1, issue number 2, and issue number 3.
Okay, you can continue.
members of the tribunal, the principle vigilantibus non normativus jura supplement applies here. The law assists those who are vigilant, not those who sleep over their rights. Since the respondent failed to bring its counterclaim within the limitation period, the counterclaims must be rejected as time barred. If the members have no further questions, I would like to proceed further.
Proceed.
I now move to the next issue, which is issue 5. Issue 5 concerns whether the clause 3 of the GCC protects the respondent from paying damages irrespective of the reason for the delay. It is respectfully submitted that clause 3 cannot exclude the statutory rights to compensation under the Indian Contract Act. My submissions here are in 3 folds. Firstly, the contractual clauses cannot override statutory rights. Section 73 of the Indian Contract Act provides that a party suffering loss due to breach of contract is entitled to compensation. A contractual clause cannot exclude its statutory protection. The Supreme Court in Kalashnar Associates versus Delhi Development Authority stated that damages must be determined according to Section 73 of the Indian Contract Act and principles of the actual laws. Secondly, a party cannot take advantage of its own wrong. Members of the tribunal, the respondent itself caused delays due to site hindrances and administrative obstacles. The Supreme Court has repeatedly held that no party can take advantage of its own wrong. Therefore, the respondent cannot rely on Clause 3 to escape liability of damages caused by its own conduct. Thirdly, the exclusion clauses must be strictly interpreted. Courts consistently interpret exclusion clauses narrowly, especially where public authorities are involved. Therefore, Clause 3 cannot be used as a blanket protection against liability. Therefore, Clause 3 does not protect respondent from paying damages where delay occurred due to its own conduct. I now proceed with the next issue, which is issue 6. Issue 6 concerns whether the counterclaim number 1 is barred due to failure to issue prior notice before completing the work at the contractor's risk and cost. The claimant submits that the counterclaim is invalid due to procedural illegality and wrongful termination. My submission here are in 3 parts. Firstly, the termination itself was wrongful. Under Section 55 of the Indian Contract Act, when time is specified in a contract, firstly, the termination itself was wrongful. Under Section 55 of the Indian Contract Act, when time is specified in a contract, termination is only valid when delay is attributable to the defaulting party. Here, the delay occurred due to hindrances attributable to the respondent, making termination wrongful. Secondly, the respondent failed to issue mandatory notice.
They did give you a notice. They did give you a notice. Before termination.
They didn't give us a notice that they are engaging with another contractor, which was unfair. Even if the termination is happening, we are the other party who has signed the contract with the party in front of us. So they are obligated to give us a prior notice and a prior information that they are going to engage the new contractor for the leftover work.
Is there any statutory provision or judicial authority which mandates that you have to mention that we are going to get this work done on
Yes,
this and
sir. It is obligation in a contract. When a contract is being signed between 2 parties or 2 people, there is a contractual obligation that if that contract is being terminated further, the other party should inform the party which is performing that contract in the present time. If
there is a judicial authority, why don't you argue that?
Yes.
That it was mandatory on their part to inform you about the risk and cost.
I'll just
You
say
should have
that.
researched.
I'll just cite the case law and then I'll cite a section from the Supreme Court in Kalashnath Associates and Delhi Development Authority held that damages must be determined according to Section 73 and principles of its actual laws. And the Indian Contract Act also provides that a party suffering loss due to breach of contract is entitled to
Where is
compensation.
this written that the term risk and cost must be mentioned in the notice terminating the contract or the notice issued before terminating the contract? This section 73 does not address this issue. Kalashnath Associates also does not address this issue.
Just a second.
Your argument is merely because the government did not mention that we are going to get this work done on risk and cost, hence this notice is not valid for seeking compensation.
Risk and cost is valid. Risk and cost recovery requires proof of actual loss and valid termination, and a liability cannot be imposed without proof of loss.
Suppose notice must be saying that we are going to hand over the work to someone else. You are delaying it.
Sorry, sir?
You are delaying it, that's why we are going to hand over the work to someone else. Suppose notice must be saying this.
Sir, talking about delay, the first delay was caused by the respondent itself.
That's your contention.
Sir is talking about the show cause notice that is given in your facts.
What is lacking in there? Your argument is that since it was not informed to you that risk and cost contractor will be appointed, that's why this claim is not maintainable. This is your argument. Now the issue is, which is the provision of law or any judicial precedent which says that one has to mention that I am going to get this work done on risk and cost of contractor's liability. Then only you can claim compensation for getting the work at the risk and cost.
Sir,
there are many judicial precedents in this regard.
yeah. So in this,
there are many judicial precedents which mandate it.
Yes.
If you do not mention risk and cost, then entire claim for getting the work done at a higher price will not be entertained by the tribunal or the court.
So in the case law of MS Arizona Enterprises Limited versus Union of India, procedural requirements cannot defeat substantive right.
Okay, next issue.
We were at the issue 5. I would like to proceed with the second fold of the issue.
So what's the next issue?
I now proceed with the issue 6. Issue 6 concerns whether the counterclaim number 1 is barred due to failure of issue prior.
This has been addressed.
I would like to now proceed with issue 9. Issue 9 concerns whether the contractor is entitled to claims raised in the statement of fact. It is respectfully submitted that claimant is entitled to the reliefs sought in the statement of claims. Firstly, the respondent has failed to establish any breach. Members of the tribunal, the respondent has not produced evidence proving that the claimant committed any contractual breach. In fact, the report demonstrates that project delays were caused by site hindrances and administrative issues attributable to the respondent. Secondly, the respondent has failed to prove actual damage. Under Section 73 of the Indian Contract Act, compensation can only be awarded when actual loss is proved. The respondent has failed to establish the existence or any quantum of such loss. Thirdly, the counterclaims are legally unsustainable. Since the respondent's counterclaims lack proof of breach, proof of damage and procedural compliance, they cannot defeat claimant's claims. Therefore, the claimant is entitled to the claims raised in the statement of claims. My next issue is issue 10, which concerns whether the respondent is entitled to the counterclaims raised in its statement of counterclaims. It is respectfully submitted that the respondent is not entitled to these counterclaims. Firstly, the risk and cost claim is procedurally defective. Risk and cost recovery requires prior notice and opportunity to remedy the breach. Since no such notice was issued, the claim is procedurally invalid. Secondly, the remaining claims are too remote. Under Section 73 of the Indian Contract Act, damages can only be recovered if they arise naturally from the breach. Administrative expenses and HRA costs claimed by the respondent are too remote and speculative. Thirdly, the claims fall within the expected matters. Certain matters are excluded from arbitration under the GCC clauses 3 and 4, commonly known as accepted matters. Such matters cannot be adjudicated by arbitration.
If you have anything else, anything substantial, then you may take 30 seconds to finish. Otherwise, your time is up.
I would just like to proceed with the closing statement. Members of the tribunal, the delay in execution of the project was not a consequence of any default on the part of the claimant, but arose due to continuous hindrances and failures attributable to the respondent. The claimant acted with due diligence and repeatedly brought such issues to attention, yet was deprived of a workable environment necessary for performance. The respondent cannot now shift the burden of its own defaults onto the claimant, nor rely on any contractual clauses to escape liability. In the light of the submissions advanced, it is most respectfully prayed that this honorable tribunal may be pleased to allow the claims of the claimant as are set out in the statement of claims, declare the termination of the contract by the respondent as
Okay. Those are the formal conditions. That's all from your side? Yes.
Counsel says approach the bench. The counsel seeks permission to address the bench collectively as your honorable tribunal. Yes, much obliged. May it please this honorable arbitral tribunal, I, counsel appearing on behalf of the respondent, Department of Public Works and Logistics, most humbly seek the leave of this honorable tribunal to present my submissions in the present matter. The jurisdiction of this honorable tribunal arises from the arbitration clause contained in the contract between the parties, which the claimant invoked following the respondent's termination of contract. The counsel shall be making two submissions before this honorable tribunal. First, covering issue number 1, 2 and 3. That is, the respondent submits that the statement of claim is not maintainable as it has been instituted by an unauthorized person and the claimant's claim are barred by litigation where the respondent's counterclaims are within litigation. Second, covering issue number 4 and 5, stating that the claimant is not entitled to any relief, having accepted extensions to subject to nil financial effect, and in any event, clause 3 of the general conditions of contract bars such compensation claims. The counsel would like to proceed to state the facts of the cases briefly.
Facts is what we
They have already stated what the facts. Please come to the point.
Come to the first issue.
Much obliged. My first submission has 3 grounds. First, statement of claim filed by unauthorized person. It is humbly submitted before the honorable tribunal that the statement of claim is procedurally defective as it has been instituted by an unauthorized person. The claimant entity is a partnership between Agni Super Infra Co Limited and Vesh Construction Co Limited, yet the statement of claim has been signed by only one director of the partner company without authorization from the partnership or the other partner.
What is the effect?
Is
it liable to be rejected on that ground?
Lordship,
is the statement of claim liable to be rejected on that ground? Let's assume the worst. It is not signed by an unauthorized. It is signed by an unauthorized person. What is the effect?
Your honorable tribunal, it is a procedural defect.
Exactly, that's what I am saying. So procedure is advent of justice.
Lordship, what is happening is it affects the root cause of the maintainability of this of the claim. That is why we are stating that the.
That's a precise question our ladyship is asking you.
Yes, Your Lordship.
Is the statement of claim liable to be rejected on this ground alone? Can the statement claim be rejected?
Lordship,
I am assuming it in your favor. I am saying that an unauthorized person has signed it, right? What is the effect?
Yes, Your Lordship, Your Honorable Tribunal, apologies. It can be rejected because the partners here both are equally liable.
Any precedent on this?
Yes, Your Lordship. Honorable Tribunal, my apologies. The Supreme Court in United Bank of India versus Naresh Kumar, that was held. This was held in 1996. Furthermore, it was backed by another case, Church of Christ Charitable Trust versus Oniaman Education Trust. That was held in 2012, and it held that the source of authority must be established by the person instituting the proceedings. And if you
can this defect be rectified?
Yes, can it be rectified?
Your Honorable Tribunal, it can be rectified. However, in the initial it can be rectified, but it should be done in the initial parts of the proceeding. Moreover,
where is so mentioned or provided that it can be rectified in the initial period but not later on?
Honorable Tribunal, it is not such verbatimly stated somewhere, but the respondent pleads that certain procedural defects are like curable, but the present defect goes to the root of the maintainability of this claim, as no proof of authority has been given by the claimant.
But you have not answered the question raised by Arun whether the statement of claim is liable to be rejected or not on this ground.
yes, it is liable to be rejected. However, since given the limitation,
You are not confident enough, I guess.
Lordship, if may I back the answer?
Yes, please.
It would
Yes,
satisfy
yes,
the
please take your time. Take your time. But also keep a tab on the time because you have to address 5 issues.
Indeed, Honorable Tribunal. I could, even if the ratification, okay, while ratification may cure the certain defects, it is respectfully submitted that such ratification must be clear, specific and placed on record. However, the claimants have not placed any kind of proof that is showing the
Which
authorization.
provision demands proof? Is there any provision under Partnership Act which demands proof that the other partner has also authorized?
Just a moment, Your Lordship.
Did you hear the argument advanced by the claimant? You asked the same question.
So, Section 19 of the Indian Partnership Act 1932 states that it basically applies. Okay, the Honorable Tribunal, can they please refer to the compendium, page number 4, that it has written that implied authority of partner as an agent of the firm.
Is it in your favor or against?
Lord, Honorable Tribunal, ratification can be, it is a curable, however, our major submission would be.
No, it's curable, it's fine. It's what it is not cured. One thing is there. Second thing is whether one person can, one of the partner can file a petition for the arbitration for the purpose of arbitration or not.
Lordship, Honorable Tribunal, I am not able to understand. Can you please reframe?
They are the two companies. They enter into partnership.
Yes, yes.
Whether one company can file it or not, cannot file it.
Lordship, Honorable Tribunal, under Section 25 of the Indian Partnership Act, both of the partners are jointly liable to showcase the authorization. However, since one of the, and even if one of the partners has shown that they are authorized, given the authorized notice, there is no partnership deed, no power of attorney, or no board of directors that is given here by the claimant.
So is it not the implied authority of a partner of a partnership firm to invoke the arbitration clause? That's the precise question we all three are asking you again and again.
Lord, Honorable Tribunal, if
The answer was given by the
satisfied,
claimant's counsel.
can I proceed with that?
Okay.
Read section 19, subsection 2, and then clause A. Do you have the partnership act?
Yes, Your Lordship.
Why don't you read that?
In the clause 2 states that in the absence of any usage or custom of trade, to the contrary, the implied authority of a partner does not empower him to, clause A, submit a dispute relating to the business of the firm to arbitration.
This was the only answer. You have listed 10 minutes on this issue only.
Apologies, Your Honor.
You are wasting.
If I can proceed with my
Yes,
assumptions. Thanks so much. Coming to the second part of my first submission, claimants claim are barred by litigation. Even assuming arguendo that the claim was validly instituted, the claims are ex facie time barred. The respondent terminated the contract on 15th of October 2016, while the claimant approached the Delhi High Court for the appointment of an arbitrator only in November 2020.
The court has left that question open, right? So only whether appointment of arbitrator was within time, that they must have considered an appointment of arbitrator, right? So how is it not within time?
Lordship, Honorable Tribunal, mere notice that was submitted is not sufficient. If they had so much claims that they were going through so much losses, they did not act diligently to pursue the arbitration proceeding. They could have done this even before 2020. So that is what the respondent is trying to do.
Then how do you justify your counterclaims? You also did not invoke the arbitration clause. You also did not file any statement of claim, etc. This is only when they file a statement of claim, you file your counter claim. So under which provision of law you justify the delay?
Honorable Tribunal, if I can answer. The cause of action is different for the respondents. It starts with, can I further proceed? Thank you. Basically, for the cause of action starts when the termination of the contract took place in October 2016. Further, our losses were quantified after the completion of the work that was done by the risk and cost contractor in 2017. That is why we are stating that.
2017?
Yeah, after completion of balance work
was complete then.
Sorry,
The work was completed then. Did you not award it for a particular price? And would you not have informed the nil
financial effect
on the other person? Or was it only limited to this contractor?
Lordship, the work was.
So you have quantified it then?
Can I answer?
Yes, please.
Honorable Tribunal, the work was done between 2016 to 2017. That even after the termination of contract, the work was still going because we, the DPWM, wanted the work to be completed. And at that time, when the termination of contract took place, only 75% of the work was done. So that is why we had awarded.
You did quantify it and you gave it to another contractor for 300 crores. Yes or no?
Lordship,
quantified.
If we could refer to the moot prop, case number 2, it is stated that DPWA terminated the contract with its letter dated 15/10/2016, and then it is written that DPWA then constituted board of versus.
See the last line, please. Rishikesh Infra Company Limited for a sum of 300 crores. So wasn't it quantified then? Because the nil financial effect would also fall on Rishikesh, no? Why only on them?
Honorable Tribunal.
What the limitation period for the government agencies to file their civil suits or the invoking the arbitration clause, etc. Are you aware of that privilege given to the government? Have you heard the arguments and one of the claimant and questions raised by the tribunal?
Honorable Tribunal, it was 13 years.
13? 30 years. Which article provides so? You have the limitation act?
Just a moment.
Sir, I had already helped you so much in the beginning.
Read article 112. We are helping you while you are raising the question. Read article 112 of the limitation act. You also don't let them. All right, you proceed further.
You continue.
Apologies.
No, no, it's fine. You continue.
If it's, can I further?
Sir has already said.
I just wanted to read.
Where from you want to continue?
Further, that respondents' counter claims are within the limitation. Respondent counter claims only arose after the term that was established earlier also after the termination of contract. And further, to substantiate what I was stating, the Supreme Court in State of Goa versus Praveen Enterprises held that arbitral tribunal is competent to adjudicate counter claims arising out of the same contract and arbitration agreement. Accordingly, since the respondents' counterclaims are arising directly from the same contract and they are independent claims, so breach of the same, hence they are both maintainable and within the period of limitation. If the Honorable Tribunal is satisfied, I will further proceed with my submissions. And I proceed to my second submission, that is acceptance of the extension of with nil financial effect. It is respectfully submitted that the claimant was not coerced into accepting the extension letter containing the condition of nil financial effect. The stipulation was voluntarily accepted by them, and further there was no protest done by the claimant's side. Therefore, it operates as
not a practice of the government to put the other party, the contractor, in economic duress situation and seek extensions from them. Is it not a practice? It is a widely, I think, done practice.
Honorable Tribunal, in the present case, the claimant had voluntarily accepted the conditions of the contract. That has
show me where is it written voluntary?
Lordship, Honorable Tribunal, coming to the moot prop, page number 1, it is stated that the contract valued at 750 crores included specific clauses regarding timing, essence of the contract, confidentiality.
Only a voluntary.
Okay, Lordship.
it's not there.
Since they
You
had
should not presume the facts and do not state the incorrect facts before the tribunal. You should say, is there any judicial authority that provides the mechanism to determine whether there was any coercion or not? There is a landmark judgment by the Supreme Court of India by Justice Ravindran. National Insurance Company versus Polymer Bogara. Did you read it?
Yes, sir.
Then the conclusion is provided. You should take the plea of that conclusion.
The Supreme Court in National Insurance Co. Limited versus Bogara Polyfab had held that where contractual terms are accepted without protest, such acceptance is ordinarily binding unless clear evidence of coercion or fraud is shown. Similarly, Union of India versus Master Construction Co. that was held in 2011, the court had held that a contractor who accepts contractual benefits without protest cannot later raise claims inconsistent with the terms under which those benefits were accepted.
So even if there is a coercion, what are the consequences of that coercion?
Lordship.
What are the consequences of the coercion even if Government of India has applied that on the contractor?
In the present case, the government, the DPW has not done a...
Even if it is so, then you could have argued that the effect of coercion is just to get this contract terminated. You cannot seek any kind of compensation and you cannot justify the delay. This is the argument which should have been advanced by you. You should read section 19 of the Indian Contract Act which provides the consequences of applying the coercion.
Can I just get a minute of extension to just proceed? Yes,
You finish it off.
Yes, please.
How long you will take to finish it up?
Just 30 seconds max. 1 minute. For 1 minute, if it's that important. Coming to the last condition, whether condition 3 of the GCC protects the respondent from paying damages, may please this honorable tribunal. Condition 3 of the general conditions of contract expressly bars any claim for compensation that is arising from extensions of the term. The clause unequivocally provides that no claim for compensation, however arising as a result of extensions granted, shall be admitted. The claimant's claim for overheads and loss of profit arise solely from the extended execution period and therefore fall squarely within the contractual part. The Honorable Supreme Court in the ONGC Limited versus Saw Pipes Limited that was held in 2007 has held that arbitral tribunals must give effect to the contractual terms agreed between the parties. Since the claimant sought and accepted multiple extensions, including one with nil financial effect, and it is contractually estopped from claiming damages for the extended period.
The same provision would also apply to you when you are talking about log accounting.
Honorable Tribunal,
finished?
Yeah, that would be answered by my co-counsel. Unless this Honorable Tribunal has any further questions, this would be the respectful submission.
It's fine.
My
We have
co-counsel.
already questioned you. We have already.
My co-counsel shall now address the remaining aspects of the dispute. It was an honor.
All of you have done well.
Counsel seeks permission to approve. Counsel seeks permission to address the matter as the much obliged. May it please this honorable tribunal, I appear on behalf of the respondent and will address issues 6 through 10. At this stage of the dispute, the tribunal is essentially faced with two main questions. First is which party was responsible for the delay in execution of the project, and second is that once that responsibility is determined, whether the claimant is entitled to the claims raised in the SOC or whether the respondent is entitled to recover its counterclaims arising from the claimant's breach. To assist this,
I guess we will get some benefit from there.
effect of such failure when time is not essential. But time is essential.
Okay, is there any judicial authority how to make the time essence of the contract even if it is not essence?
Once you have given them a time, extended the time, then the second time also you extended the time.
Yes, sir.
It means the time was not the essence of the contract.
Your Lordship, here again, the time as stated in the contract was always essential. essential to the contract.
That rather shows, demonstrates that there was a delay on your part also and you agreed to extend the time.
Your
Some
Lordship,
lapses were from your own
Your
side.
Lordships, we are not denying that there were no delays from the respondent side. We are saying that there, in a large infrastructure project, it is normal to have delays. But here,
Why was their delay not accepted, my dear?
Your Ladyship, because one of the main parts of the contractor is to form a CPM chart, which is a critical path method chart, which is used to estimate the delays that would apply to a project. Here, the claimants failed to even make a basic critical path method chart, which
Was that the only reason?
No,
You
Your
said
Ladyship.
that they had completed 75% of the project.
Yes.
So the critical part was complete.
Critical
Only
path.
25% for the purpose of completion was left out.
Your Lordship, after the termination of the contract, 25% was still remaining of the
That is what I was saying. Was that 25%? Can you call that critical? Does it fall within that category of CPM?
Your Ladyship, here we are talking about.
Did you read this landmark judgment by Justice R.C. Lahoti while he was Supreme Court judge, Northern Railway versus Sarvesh Chopra, which provides the situations where time can be made essence of the contract even if the time had been extended in past?
Yes,
Then
sir.
read this.
No, Your Lordship, not
This
that.
is exactly going to benefit you.
If Your Lordship, my main argument here is that even after accepting the delays and granting extensions, we can't say that the time, the essence of the contract was diluted completely. Here we have again asked for penalties for that extension, marking that time is still remaining an essence of that contract.
Okay.
May I proceed with the argument? Here, Your Lordships, as I was saying, the prolonged delay was not caused by any acts of the respondents particularly. Rather, it resulted from the claimant's own inefficiencies, including failure to deploy adequate manpower, frequent machinery breakdowns, failure to prepare a critical path method, as I mentioned earlier, which is used for project planning and monitoring and is an essential part to estimate the delay in a particular project. All these facts demonstrate that the claimant failed to perform its contractual obligations diligently. The second part of the submission, Your Lordships, is that the claimant cannot rely on an internal departmental recommendation to claim legal entitlement to a third extension.
Why not?
Your Lordship, because an
How
internal
will you privilege for that?
noting as stated in state of
In
Bihar.
the internal notice, if you say that someone is entitled for the 10 rupee and you don't give him 10 rupee, you instead give him a 5 rupee. Justification is for 10 rupee, but you have given 5 rupee. Does it mean we should accept that?
Your Lordship, as I was saying, in state of Bihar versus Kripalu Shankar, it was stated that mere opinions during governmental decision processes do not bind the authority and the responsibility.
That's what sir is saying. These are not opinions, they are giving reasoning.
Your
The
Lordship,
reason is given by you, not the opinion is given.
the reason was that the opinion was taken note on the internal noting.
Opinion is a different thing.
It is
If the
opinion
opinion
is based on a reason.
Your Lordship, if the opinion was based from the engineer in charge who has the sole authority, then we could have accepted it. But here it's just an opinion of a mere engineer who can have
Project
limited.
engineer, please, my dear.
Yes,
It's not
sorry.
engineer.
Apologies.
And who is the chief engineer here? Project engineer is the person who is deputed at the site and he is the person who gives the instructions to the contractor. So he is the best person to assess the site conditions.
But Your
So
Lordship,
this is totally wrong.
But Your Lordship, there is a reason that we have a chief engineer, that engineer in charge. Because
That's a hierarchy, that's a different thing. But the person who is looking after him must be knowing what is going on.
But here the authority, that is why a position was made for the engineer
And
in
it is
charge.
not that way that it was rejected.
No, I didn't say accepted.
So that's what sir is
Opinion
saying.
is there.
the bench that it is important
How
that...
can you claim the privilege of the same?
Sorry, Your Lordship?
How can you claim the privilege that you can't claim anything on the basis of the opinion of the person potentially?
Because again, there is a judicial precedent on this, State of Bihar versus Kripalu Shankar, that a competent authority should have that opinion, and that opinion needs to be communicated
You
to
have
the...
not said so anyway that a project engineer is not a competent authority.
Your Lordship, I stated earlier that the project engineer was not a engineer in charge should be the competent.
Sorry to get offense to that.
May I proceed with the argument? Your Lordship, in the present case, no third extension was ever issued. Instead, the respondent issued a show cause notice dated 6th October 2016 and subsequently terminated the contract on 15th October 2016, clearly reflecting that the authority, DPWL's final decision was to not grant any further time. And this should be taken as the precedent, and further the claimants should apply to this. Now, in the
So
third...
what was the criteria fixed in the contract or by the respondent to decide when to give the extension, when not to give the extension? You granted 2 extensions, refused for the third extension, that was merely for 3 months. What did you grant? Was there any criteria written down somewhere or any asset?
On granting,
or any formula, yes?
Your Lordship, we at the start understood that there were situations like floods and shortages of labor, and the respondents understood these criteria and granted those extensions. But we can only indulge in extensions to a certain point when the contract is essential to them and it needs to be completed. After granting 2 extensions, till what time and till how many extensions can the respondents grant extensions again and again? That's why we had to put a stop, because we wanted the project to be completed. That's why we terminated the contract and further gave the tender to Rishikesh Infra.
So, did you study why the contractors claim for overheads and loss of profit not maintainable in this case?
Yes, Your Lordship, I will be further addressing that in my submission. The last part of this submission is that the respondent was fully justified in terminating the contract.
I think that's done. We'll move on to the next.
Okay. Now, I would like to move to my submission 2, which is that the claimant's claim fail and the respondent's counterclaim are fully justified. Here, the first is that counterclaim number 1, which is 112.5 crores, is maintainable because respondent complied with procedural fairness before terminating the contract. Here, Your Lordship, the respondent issued a show cause notice on 6th October 2016, calling upon the claimant to explain why the contract should not be terminated for non-completion of the project. The claimant failed to submit any response within a 7-day period that was provided to them by the respondents. Thus, the respondent therefore lawfully terminated the contract on 15th October 2016. Further, Your Lordships, in MSK Project Limited versus State of Rajasthan, it was stated that when a contractor commits a breach, the employer completes the remaining work through another agency. The additional expenditure incurred constitutes recoverable damages arising from that.
It is not necessary to provide a clear notice to the contractor that the work will be done at your risk and cost.
Here, Your Lordships, a show cause notice was given.
Risk and cost.
A risk
The aspect of risk and cost.
Here,
you did not mention that. So what are the consequences?
There is no mandatory statutory provision that constitutes that the employer should give a risk and cost notice.
Many judicial precedents on this. Many judicial precedents on this.
Your Lordships, but there are many judicial precedents on the respondents giving.
Cite one of them which says that risk and cost notice is not required to be given to the contractor before claiming.
In MSK projects versus State of Rajasthan, Your Lordship, here it was MSK projects versus State of Rajasthan.
Okay.
It was stated that
by whom? By Supreme Court, High Court, or
by the Supreme Court in 2011. In 2011.
Okay.
It was stated that.
You have got 1 minute only now.
Could I ask for an extension of 2 minutes? Much obliged. Here it was stated that additional expenditure it is recoverable by the respondents or the employer here when there is a breach in contract and that contract is further given to another agency.
Address the aspect of risk and cost. Is there any judgment which says that there is no need to make aware this contractor that the work will be done at your risk and cost?
The council is not aware.
Not aware.
Okay, that's very nice for you to have been accepting it.
First
Okay, let's move on.
Much better. Here, the second, if I could.
But you address the query raised by the bench about this aspect, how they claim for loss of profit and loss of overheads not maintainable.
I will come to that. So following that termination.
Just a suggestion.
Yes.
It falls from the bench. You need to answer that first.
So cost of overheads and everything. Could you please restate what were the two parts that you were saying?
These are the claims. You must have gone to the claims. Loss of profit
yes,
and cost of overheads.
These are speculative costs firstly, and secondly that they are direct consequences of the breach of contract that was done by the claimants. And according to section 73 of the Indian contract, and also stated by the claimants that when there is a breach.
There is a related question, alright. Your two submissions are correct. But the related question is when the contractor applies the Hudson formula or Anden formula, are they claim not maintainable in absence of the proof? Is there any judicial authority on this aspect?
Your Lordship.
You didn't read this Unibros versus All India Radio recently passed by the Supreme Court of India?
I will read it after. Your Lordship, coming to the second submission of this argument, the claimant is not entitled to the claims raised in its statement claims as I stated. Here in Rajasthan versus Navbharat Construction Company, they recognize that contractor responsible for the delay cannot claim damages arising from its own breach. Here, as I mentioned and proved earlier, that the breach was done by the claimants and they can't further claim damages.
Convinced with that proposition. We think that there was a delay also from your side.
Sir,
I already asked you that question.
Why don't you mention the clause of the contract which says that even if there is a delay, the government will not be liable to pay the contract? You have not relied upon that till now. It's for your benefit. It's an accepted clause. You know the doctrine of accepted clauses?
No.
You haven't gone through it.
Your Lordships, since the claimant failed to mobilize any adequate manpower and resources and did not complete work within the extended timeline, the claimant cannot shift the consequences of its own default onto the respondent. Further, Your Lordship, the respondent is entitled to recover its remaining counterclaims as they are directly through the claimant's breach. Now, following the termination, the respondents incurred several expenses necessary to ensure completion of that project, including measurement of unfinished work, supervision costs, watch and ward arrangements, and other administrative costs.
How is your claim for loss on account of payment to HRA is maintainable?
Your Lordship, because that was the direct consequence of the extensions that were granted.
Was it made aware to the contractor in the beginning of the commencement of the project or at the time of signing of the contract?
That
is it not enforceable for the contractor?
Your Lordship, there is no specific clause that it is mentioned in the Mutra. It is silent on that occasion. Your Lordship, in the Supreme Court, McDermott International and Company versus Burn Standard Limited, it recognized that losses flowing directly and naturally from the breach in construction contracts are recoverable where they are from the where they form the proximate result of that particular default. In addition, as Your Lordship stated, for the HRA payments, the claimant delayed forced the respondent to continue making HRA payments to the DRDO personnel. Here, since the housing project schedule was for completion in 2015 and was only completed in 2017, we had to pay that forward. Further, Your Lordship, these losses were direct and foreseeable consequences of the claimant's breach and therefore are recoverable.
Can you just claim this amount without providing any kind of proof that you have actually paid HRA to the officials, or just speculation can be made and accepted by the tribunal?
Here, Your Lordship,
you said that they have not provided any kind of proof. This is speculative. So the tribunal also does not know whether you have paid HRA to your officials.
Your Lordship, the proposition is...
You are presuming the things in your favor.
Your Lordship, we are assuming because...
Then claimant can also presume all these things, right? No, they cannot. You didn't read the program properly.
50 seconds for your
You
can get a chance to rebut.
Yes.
May I receive the prayer?
We know the prayer.
Yeah, we know the
Prayer to pata hai.
We are aware about it.
It was an online update.
Yes, in rebuttal you have to say something.
Yes.
Yeah.
After the following opening statements and all the defenses taken by both the parties, I would like to ask some questions from the...
You don't ask.
You don't have to ask. Now you have to revert whatever they have said, that is revert. There too you have to reply that how they are wrong.
So, talking about the show cause notice, which was mentioned by the respondent, we have not replied formally during the third extension letter, but during the third extension letter, we did cited all the problems and hindrances which were caused at the site, and even the engineers from the respondent side were present on the site, and they had the knowledge about the hindrances we were facing for the delay. And also, I would like to add that during the first extension, the first delay was caused by the respondent, which was handing over the site, and it was...
Whether your third letter was reverted by them in any manner?
No, sir.
No.
No, sir. It was not
It was not replied by them.
As they are claiming that they were not aware about the hindrances you were causing, as we didn't give any formal notice, I would like to just add to that we were also not provided with any formal notice that they are engaging with a new contractor to complete the further work.
How does it make any difference to you? You know it that if the project has been completed only 75%, and the natural corollary is that they will get it completed by some other contractor. So by the natural one, they will not leave this building 75% only.
Sir, apologies. I would like to add, if 75% work was completed by us during the first extension, and only 25% of the work was left, even their own engineer recommended that we should have been granted for the third extension to complete the further project. And
they were bound to grant to any extension.
No, they were not bound, but it was recommended by them, and it is a verbal
Recommended by whom?
recommended by their own engineers who were
At the site.
yes. And even all the hindrances which were happening on the site during the construction, the engineers were present on the site, and they had full knowledge about all the hindrances we were facing on the site, and we didn't receive any kind of formal notice.
What is your answer to their submission that your claims are speculative one, like headquarter overheads and the loss of profit, etc.? What is your answer? How have you quantified this claimed amount, 21 crore, and then for this loss of profit, 36 crores?
Your Lordship, I would like to say that we did complete 75% of the work, and
Issue is not that. Issue is how have you quantified this amount? You have just filed the calculations. They have denied those calculations. Is there any particular formula in your, on which you are relying upon? Is there any process through which you have just, which is internationally accepted?
No.
Like Hudson formula, Indian formula, Lecce formula.
No.
You haven't examined that. You have not applied that.
We haven't examined
Then only you can
these
claim these
formulas.
amounts.
We are relying upon one thing, which was a contractual trust, which was when a contract is signed between two parties, it is an obligation of the other party to inform us, to let us know if they are engaging with other contractors.
Quickly, you have a minute left.
Yes, and I would also like to state.
Under which provision of law you are claiming interest at the rate of 18% on the claim number 125? You are claiming interest. Which provision entitles you for the interest? And what kind of interest you are seeking here? Pre-light, pending light, or future interest? See claim number 6.
Sir, I'm not aware.
Are you seeking all 3 kinds of interest? You are seeking interest under the provisions of Arbitration and Conciliation Act?
Yes.
Or you are, which provision? Or you are seeking interest under the provisions of Interest Act? You know about the Interest Act? You don't know. You know about the provision of interest in the Arbitration and Conciliation Act? Section 31. You should read that.
I would like to.
They are seeking cost of arbitration, counterclaim. Respondent is seeking cost of arbitration under counterclaim number 8. How do you defend it? Is there any provision in the Arbitration Act providing costs of arbitration? Did you read section 31A?
I would like to add wrongful termination too. If they say anything, if they are saying the termination was wrongful as the delay was not attributable to the claimant, and
These aspects you have already addressed. How do you justify your claim number 5? Claim number 5 is for reimbursement of legal and administrative costs incurred during the present after costings.
Just for 30 seconds, wait,
Yes. Claim number 5.
so we are claiming.
What is the nature of this claim?
So we are claiming towards a reimbursement
That
of.
we have read. What is the nature of this claim?
You have left many issues unanswered. You have not answered the many issues. Anything you want to say?
Yes, I would like to add the nil financial effect. I would like to say the acceptance of the extension with nil financial effect cannot amount to waiver of the statutory rights under Section 73 of the Indian Contract Act.
Section 73 does not talk about the waiver.
Sir, I'm not talking about waiver, I'm talking about acceptance of the nil financial effect.
Section 73 does not talk about this also. Section 73 is only about the compensation for the breach of the contract. Nothing else.
That too, I would like to add that to the Section 73 for the compensation too. And I would like to say that if the extensions were granted to us, then time was not the essence, and even if the extensions were granted.
Does it mean that you will complete the project in next 10 years, 15 years, 20 years as per your leisure? If time is not the essence, is there not section 46 of the Indian Contract Act which says that the work has to be completed within a reasonable period of time?
Sir, we did
You
complete
cannot
the
get
work
the
in a
playground.
reasonable period of time when the first extension was granted.
Service Chopra judgment, did you read that? That says that time can be made essence of the contract at any time, even if it did not remain essence of the contract. Even if it was not so provided in the contract itself. Time can be made essence of the contract by just giving a notice. Please.
कोई बात नहीं, आप आगे बोलिए. One sentence on each issue quickly. Okay? Whatever you want to rebut.
Don't worry, you are not in the court, you are not
Yes,
don't worry about
yes,
that.
absolutely. And furthermore, remember you did very well.
And secondly, winning something or not winning something is not that important, whatever you may be thinking now. Whatever is that you are presenting it properly, that's fine.
I would like to add in the no written notice respond. The respondent's engineers were continuously present at the site and were fully aware about the hindrances affecting the execution. A party cannot claim ignorance of the circumstances within its own knowledge. I would like to cite Arosa Enterprises Limited versus Union of India, the case here, and I would also like to add the respondent cannot rely on the absence of paperwork to deny realities. It was because the respondent was fully aware of it. Now I would like to proceed with the wrongful termination. According to Section 55 of the Indian Contract Act, the termination for delay is justified only when the delay is attributable to the defaulting party. where the delay is caused by promisee, termination cannot be sustained. And Section 73 by the Indian Contract Act is also used here. The claimant is entitled to compensation of losses arising from the wrongful termination too. The termination was unfair. Even if the termination is being invoked by them, it should be fair. So we don't face any issues further. But the termination was unfair and
Should be fair or should be actual?
so it should be fair and actual, both the things. Because if we talk about law, then it should be fair. If we talk about the obligations and the paperwork, that should be actual.
That's all?
Yes.
Thank you.
Yes, quickly please. 5 minutes to.
Your Lordship, first I would like to address the main two rebuttals that were given by
all. Quickly.
Most of them were whatever the questions, and then I will proceed with the questions for the rebuttals for the claimants.
Rebuttal is only to the points, whatever they have argued now.
Yes.
Not to the entire case.
Okay, Your Lordships. First is the
rebuttal.
first is the show cause notice, Your Lordships. The claimants claim that we think that the show cause notice was given. Show cause notice was given and there was no response from the claimant side. That means that and it was only given to ask whether the contract should be terminated or not once the third extension was rejected. So addressing another claim, rebuttal that the claimant said that the engineers were present at the site, at the project site, and hence the respondents cannot refute and they should know that the delays were from their side. Here, Your Lordships, there were delays and delays were predominantly from the claimant side. The claimant had shortage of labor which was theirs to already estimate.
Better you answer to the sharp queries raised by the panel instead of stating the same thing again and again. These are the facts which we have already stated before the panel.
Your Lordship, so for the show cause notice, we are just saying that
You haven't come with the answer whether the term risk and cost has to be mentioned in the show cause notice or not. You have not answered that aspect. This is the rebuttal actually.
There is no mandatory provision that says that a show cause
Repeating
notice
yourself,
must be.
the panel is not with you. You should come up with some judgment. And you proceed.
Your Lordship, further, the respondents were mainly on.
You got sufficient time to inform the tribunal about the particular article which provides you 30 years of limitation period. Have you researched that in between?
Your Lordship, we do not have the information.
All right.
Your Lordships, if I could argue the jurisdiction that the claimants are coming here.
Jurisdiction is not the issue here.
The claimants are coming here with.
So what?
For their
There is no issue claimed by the tribunal on the aspect of jurisdiction. So why are you wasting your time?
Your Lordships, there were only main two issues that
Whatever the issues are there for their general knowledge, whenever the case is decided, generally on the civil side, it is only within the periphery of the issues.
Yes, Your Lordship.
Not that there is something not up here.
Here, addressing the rebuttals, there was a rebuttal for the show cause notice that we had, I forgot the specific question that they answered. I have written the answer for.
Alright, question number, your claim number 7. Under which provision of law you have claimed this?
The council is unaware.
What is the difference between pre-life, penalty life and future interest?
Future interest refers to
Future.
Okay, which year of law are you in?
third year.
Third year? You've been taught CPC?
Yes.
You've been taught totally?
Yes, last.
Then you should have been able to answer this.
Is CPC applicable in the applicable proceedings?
Only when the arbitral tribunal accepts it.
Which provision provides for that? Your answer should be based upon some provision of law, not what you presume.
I'm not sure about the
You didn't read
specific.
section 19 of the Indian Arbitration.
I was confused between section 13 and 19, that's why I couldn't answer.
You should have said both.
But I wasn't sure.
And what about the claim number 8, cost of arbitration? What is the difference between cost and costs?
Cost and?
Costs. You have mentioned costs of arbitration.
Your Lordship, here there were multiple costs.
Is there any difference between cost and costs?
Costs refers to multiple instances which occur during an arbitration. Here there were, you have to file a claim and there are multiple expenses that...
Under which provision of law?
Your Lordship.
You don't know under which provision of law your claim is maintainable? Then read section 31A. And what about this claim number 6? So claim number 5, compensation for the amount paid to the laborers.
Here, Your Lordship, the compensation paid to the laborers for doing measurement of incomplete because the contract was terminated because of the default. Here, as a subsequent...
Under which provision of law? There has to be some law, judicial precedent or statutory provision.
Your Lordship, here we are arguing on basis of the factual concerns of the...
What the law?
It's fine, okay.
According
That's all?
Yes.
Thank you.
Assessors are hereby requested to please provide their valuable feedback